Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Tuesday, May 5th, 2026. The time is now 10:16. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator. Mr. Waldo Cuellar is the interpreter. Court coordinator is Cynthia Flores. Video conference co-hosts this morning include Ms. Reyes, Mr. Córdoba, Ms. Noriega, Ms. Cuellar, Mr. Hernandez, Ms. Lozano, and Ms. Flores. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person and then those online, as measured by your login times. Ms. Flores.
Yes, Your Honor. First in person is Attorney Elisa Marsoto, page 1, number 2.
Page 1, number 2 is Ana Gonzalez Roberto Castro, cause number 2013 CVL 2313C3. Ms. Soto, who do you represent?
Mr. Roberto Castro, Your Honor.
Ms. Soto, the court marks you present in person. Good morning. Good morning, Mrs. Soto.
She might be conferring with her client, Judge.
Are you Roberto Castro? Into the microphone, please.
Yes.
Welcome to court, Mr. Castro. The court marks you present in person. Is anybody here on behalf of the Attorney General's office? All right.
Yes, Your Honor. Raul Gonzalez here for the Office of Attorney General.
Welcome to court, Mr. Gonzalez. Court marks you present by video conference. Court marks Mrs. Cotto present in person.
Good morning, Judge.
Good morning. Are you Ana Gonzalez?
Yes.
Welcome.
Guzman now, Judge.
Ms. Guzman. Court marks you present in person. The person to your left is your lawyer, Ms. Soto. Mrs. Cotto, go ahead.
Judge Madeline Escoto for Ms. Guzman. Judge, I have been able, thankfully, to confer with Ms. Soto. Judge, always a pleasure to work with her. We have agreed to, with the court's permission, to have a guardian ad litem appointed to the minor child. We have agreed to Leticia Garcia, Judge. And I had filed an order and a motion to that effect. We're asking that the court sign the same. We have conferred with Ms. Garcia today, and she will accept the appointment. And she is quite qualified, Judge, based on the circumstances of this particular child, to be able to come up with some recommendations for the court.
Excuse me, Ms. Soto.
On that point, no, Your Honor, Ms. Garcia is agreed qualified to handle this matter. And we did agree to her being appointed as guardian ad litem as necessary in this case.
The only other, I guess, decision regarding that matter that the court needs to make, let's see if there's an agreement, the payment of Ms. Garcia's fees.
We've agreed to 50-50.
Court has signed the order appointing Ms. Leticia Garcia as a guardian ad litem, tendering the original document to the coordinator.
Then the next matter is, Judge, we've agreed on a social study investigator pursuant to my motion.
And Judge, that one I did want to confer with my client on that one, up to that proposal. And we did exchange some names for that social study, but I do want to make sure that my client understands what it entails and that he's in agreement to that, because I have not discussed that point with him.
And that's fine, Judge. We can take that up at the next hearing, given that we have Ms. Garcia now on board and she's going to provide us recommendations for Dad's access to Bobby.
Court will, by agreement, abate hearing the request for the appointment of a child custody evaluator. Ms. Flores, give us 2 dates. Oh, one question, Mrs. Cotto, Ms. Soto. How many children before the court?
One child, Judge, is male, and he's 15 years old. And the second thing that we've agreed to, Judge, in conferring is that we're going to file an agreed order for you to interview Bobby. And we just ask that the court provide us your next available date. This case has some sensitivity, Judge. Therefore, time is of the essence. Bobby has an appointment tomorrow at 7:30 at Border Region. Ms. Soto has been notified. No parent shall interfere with Border Region's recommendation, whether they will say inpatient or outpatient. That remains to be seen.
And Judge, so that was discussed with me. My client also had him assessed previously at another facility. And that's one of the things that's, I guess, kind of in dispute and controversy between the parents. The restraining order restricts my client completely. He's had joint management conservatorship. So that is something I need to confer with my client because he has not had access to his child since the judge signed his restraining order. Because of the sensitive issues that have come up, he does not want to be denied access to the child. He understands that there's a need for an ad litem. I've advised him of that as well. But he doesn't want to have the court have a say in as to who is going to assess his child.
And so, Judge, just a little background, and the court, I'm assuming, I know, read the affidavit that was attached. And so, without getting too much into the facts, Bobby was self-harming. This was reported by the school. In fact, there is a subpoena. There's a Marla Alanis that I've subpoenaed today. She's a school counselor. I have her on standby because I knew that Ms. Soto was just hired and that we probably would need more time. What we've agreed, Judge, I thought, was that Ms. Garcia, after Bobby is assessed tomorrow by Border Region, that Ms. Garcia would see all parties tomorrow, including Bobby, and that she'd come up with some recommendations for interim visitation between Bobby and his father. Ms. Guzman is not here to hinder his relationship with his son. But things have happened that are concerning, and I don't want to go into those facts, Judge. I think that for the time being, I thought that we were in agreement. Bobby would be assessed tomorrow by Border Region at 7:30 in the morning. That they would see Ms. Garcia tomorrow, all parties, and that she would come up with some recommendations in the interim so that Mr. Castro would be able to see Bobby.
And just in brief response to that, and in consideration that this is being live streamed, I don't want to put the child's sensitive issues on air, but there's items that my client feels were not included in the affidavit. He's also concerned for his child. So we wait for Ms. Garcia to give a recommendation after interviewing the parties, interviewing the child, being assessed by Border Region, which is not the facility that he would have liked or that he has been communicating with. He does not want to be deprived of being there for his child and supporting his child through this difficult time. And right now he's being denied that through the restraining order. So if the court's considering waiting for Ms. Garcia's recommendation, my client would ask for an expedited hearing if he's not in agreement because he does not want to be denied any access or a say in his child's care.
And the problem was, Judge, my client took the child to Border Region last week and he interfered. And the appointment was canceled before Bobby was assessed, even though he was self-harming, and that was reported to Dad. And the next available appointment that they could give him was on the 6th, and that's tomorrow.
So let me give you 3 dates based on all of these things. I was looking at the calendar and I was really tempted just to give you the next one in June. ostensibly this child is in school and that's school period, whether it's LISD, USD, or some other educational institution, should be out by the end of May. So let's do this. I'm going to schedule this TRO and temporary orders for May the 19th at 2 p.m. Now, I asked, pretty sure I asked Ms. Flores and Ms. Rodriguez to give me other options, because I think that one might be rescheduled to the morning or have a later start time. In any event, that gives the parties some time to talk to Ms. Garcia to get the evaluation. If you agree with Ms. Garcia, then that eliminates the necessity for the hearing. If not, you'll have a hearing. And then, Ms. Flores, give us 2 dates: a final pretrial hearing in 30 days and a final hearing 30 days after that, give or take.
Mr. Honor, in 30 days, that'll be June 4th at 2 p.m.
No, 30 days from May 19th. Give or take 1 or 2 weeks. It's fine.
Your Honor, the last day in June would be June the 18th
All right,
at
Uh,
9 a.m.
at 9 a.m. And then give us a final hearing about 4 weeks after that, give or take.
July 28th.
Because we have Dr. Galvan in the midst of all of this, that may be too soon
For the final.
for the final.
Any objection?
No, Your Honor.
Well, but we definitely want to do it before the start of school. So give us early to mid-August, please.
August 11th at 2 p.m.
And so the request for the social study will be heard then on May 19th at 2 p.m. Unless by agreement,
Right,
Ms. Soto confers. Okay.
right. I'm going to schedule something in right now before I lose track, just in case there has been a request. I've calendared on my calendar, on the court's calendar, an interview with this child August the 11th at 1. Obviously, you can make other requests between now and then. It's already been made, but you can, there's a chance that it may not be needed. There's a chance it may be needed that day. There's a chance it may be needed before, but at least I've blocked it off on my time. Ms. Garcia, anything that you would like to add?
Nothing, Judge. Just one thing. I've got no problem talking to everybody tomorrow. However, I don't think Board of Regent would have any type of a written recommendation or suggestions for that matter if they are going to speak with the child at 7:30 in the morning. But I just wanted to put that on the record.
We'll provide, Judge, anything that she gets in writing. Ms. Guzman gets in writing immediately to Ms. Garcia so that she can, and to Ms. Soto and Mr. Castro, so that everybody's aware of what their recommendations are.
Well, that's concerning to my client and I, Judge, because conceivably, what if there's nothing from Border Region? Is Ms. Garcia gonna feel comfortable not recommending any type of access to the child? Because, and without putting all of the things we want to put on the record, my client does not want to not have any access to his child. He admittedly is going through a very difficult time. And he's here and we're here in person because he wanted to have the court at least give him the hope that he's gonna have access to his child promptly. And I just don't want to have him wait until May 19th without any type of access to his child.
Factually, the good thing about your case, Ms. Guzman and Mr. Castro, and I don't know who you are, I don't know your son. Obviously, you are spending time, energy, and resources to be here, so at least that indicates to the court that you very much love and care for your son. But the interesting thing, right? I don't want to say the good thing, but procedurally or factually, is that no matter the outcome, because of the timing of the situation, the court has this summer to play with those dates, for lack of a better term. So if more time is needed, less time is needed, summer's a good time. It'd be harder if this were happening smack in the middle of the school year, because it's summer. That gives the lawyers, the court, and you all and your son's schedule a little bit more flexibility. All right, so please, Ms. Guzman and Mr. Castro, make yourselves available to Ms. Garcia. She's been doing this a very long time. She's made very good recommendations, and she understands a lot of these situations. So make yourselves available, make your son available, and hear her out, her recommendation, and then your lawyers will be able to give you some thoughts, guidance, and legal advice after hearing her recommendation. Ms. Guzman, do you have any questions for the court? Mr. Castro, do you have any questions?
Just that I would like to see him. I am worried about his mental health. He was already assessed and recommended for a higher level of care, which was advised to mom right after it happened. It's already been almost a week since he hasn't been receiving that. And I'm just worried that something might happen.
The good thing, Mr. Castro, and I don't know the facts, circumstances, or the situations involving this case, but the good thing that I've heard from both lawyers is that there will be an assessment, so there's at least that safety net. Plus, Ms. Garcia was an able and capable legal practitioner in this area of law, family law. They're going to be able to provide a lot of resources that are otherwise unavailable to your son. So there's a lot of safety nets in place already. This gives the court at least some comfort. I hope it does you too.
Honestly, it doesn't, because I don't have the utmost confidence in Border Region. I deal with them almost on a weekly basis, and they are very inconsistent, which is why I went with Base Point Academy for the assessment.
Well, let me ask you to do this, Mr. Castro. Wait to hear the results before you judge it. Because if you go into a situation, and I suggest you don't say anything else.
Okay.
Because if I know already that you're biased against a result that hasn't yet happened, just don't say anything else. Don't put yourself in that situation. Talk to your lawyer. Anything else on this case, Ms. Soto?
So I guess we're extending the TRO subject to Ms. Garcia making recommendations for dad's visits.
Right.
And Judge, I want to make sure that I put something on the record and just clarification purposes. So once the recommendation from Ms. Garcia occurs and my client does agree with it and Ms. Guzman does not, can that recommendation already take effect? Instead of having to wait till May 19th, or if somebody doesn't agree, he's got to wait until May 19th to see the child?
Well, the legal answer, the only way to undo a court order is with another court order. So, I mean, even if the court felt differently, I can't change that. If the recommendation is different, certainly feel free to file an emergency request or an expedited request. But remember, even if that were true, and this is why I prefaced my comments, even if that were true, and Ms. Garcia says, and Border Region says, TRO should not have happened, factually, there's something else going on, we have a different evaluation. That's why I'm saying summer is the best time for this to happen, because if that factually isn't correct, then you can talk about makeup days. I mean, I'm just saying that that's one of many possible outcomes, which is good about the situation. In other words, your son, the outcome in your son's case will be in his best interest.
And just have one more item. Part of the restraining order states that my client cannot discuss the case, cannot disparage the other parent. He has no problems doing that. He's been complying with that and that had not been an issue. But we're asking that that be a mutual injunction. He can-
Absolutely.
Yeah, so
Absolutely,
Ms. Guzman
Judge.
cannot speak to the child about the case or anything of the court proceedings. Ask him what discussions he's had with Ms. Garcia. My client will do the same, and not to disparage each other.
Absolutely, Judge. That's part of the Webb County standing orders. And
So
the-
I
per the
tell you
local
what,
rules.
since it's by agreement, why don't you submit that agreement in writing on or before this Friday at noon? I mean, just add the word mutual and there it is.
Yeah, I'll send it to her this afternoon, Judge, as soon as I get back.
And just to follow up on that point, Mr. Castro and Ms. Guzman, I'm sure if I ask, Ms. Garcia is going to say the exact same thing, but it's very easy for the court to interview a child and see if any person has had any sort of influence. So just don't put yourself in that situation, because Ms. Garcia is going to pick on it right away. I can do the same thing, and it's just not going to bode well. So just don't talk to your son about this situation. Ms. Guzman, do you have any questions for the court?
I don't.
Mr. Castro, do you have any questions? Ms. Garcia, anything else on this case?
Nothing, Your Honor.
Mr. Gonzalez, anything to add?
Nothing, Your Honor. Thank you.
Ms. Soto?
No, Your Honor.
Ms. Escoto?
Nothing, Judge. I'll prepare the order and send it to Ms. Soto this afternoon.
Ms. Guzman, Mr. Castro, I wish you both very well. More importantly, I wish your son all the best, particularly tomorrow in his interview. Good luck.
Thank you, Judge. Thank you.
Judge, can I make an announcement for Mr. Canales? I don't see him on the docket, so the court might have already removed the case.
If it was called at the last hearing, yes.
2025 FLA 1446 C3.
Unless it's this afternoon's docket.
Yadira Jesael Salvador versus Enrique Salvador. I believe his opposing counsel, Mr. Jose Luis Castillo, filed the continuous because he's in a trial in another county.
And this is this afternoon's docket, page
Okay.
4, case 9. Yadira Hazel Salvador versus Enrique Salvador, cause number 2025 FLA 1446C3. Oliver Canales, Jose Luis Castillo, are you present? Court marks parties, lawyers not present. Yadira Salvador, Enrique Salvador, are you present? Court marks parties not present. Court marks Ms. Elisamar Soto present for Mr. Canales. Ms. Soto?
They've asked that it be just the next available date for the court, Your Honor.
Court has received, reviewed, and considered that agreed motion for continuance for the reasons stated therein. It is well taken. Ms. Flores, would you give us another setting on that case, please?
June 2nd at 2 p.m.
So ordered. Any objections, Ms. Soto?
No, Your Honor.
Alright. Any other cases for Ms. Soto or Mr. Canales?
No, Your Honor, that is all.
Judge, I did have one matter, and I think Mrs. Scott already left. She subpoenaed somebody. I don't know if that person's in the will of the court because she can be dismissed now on
She
the
is.
previous case.
Yes, Ms. Alanis is in the waiting room.
Tell me the name of that person.
Marla Alanis.
Mr. Jaime, bring in Ms. Escoto, please. Court is admitting Marla Alanis.
Yeah.
Forgot.
Ms. Alanis, if you are present, please turn on your video, your microphone, and unmute your device. Court is making that request electronically now. Marla Alanis.
Yes, can you hear me? Sorry, I'm trying to fix my computer. Hello?
We can hear you. Can you step in front of your camera, please?
I'm trying to, hold on. Let me unplug from my monitor.
As Ms. Alanis arranges her technology, this is your subpoenaed witness, Mrs. Cotto?
Correct, Judge. We're asking that it be extended to May 19th.
Ostensibly, she may appear by video conference on that day. Any objection to that, Ms. Soto?
No, Your Honor.
All right.
Sorry.
Are you Marla Alanis?
Yes.
Welcome to court, Ms. Alanis. The court marks you present. You're participating and present by video conference. Ms. Alanis, you've been subpoenaed to testify in this case. I'm going to ask that you raise your right hand. Do you solemnly swear or affirm that the testimony that you give in this cause will be the truth, so help you God?
Yes, I do.
You may lower your hand. Ms. Alanis, the court has rescheduled this hearing for May the 19th at 2 p.m. You're welcome to participate by video conference as you are right now. You're also welcome to participate in person. If you participate by video conference, I'm going to ask that you have a light source that is in front of you and not in back of you so that I can clearly see your face and determine demeanor. Do you have any, and between now and then, don't talk to anybody about this case. And we'll see you on May the 19th at 2. Do you have any questions for the court, Ms. Alanis?
No, I don't.
I do have one. You told them not to talk to any of the parties, but they can talk to me, correct? If they choose to talk to the attorneys?
Any objection?
No objection. I'd actually like for her to talk to Ms. Garcia as well, Judge.
All right, without objection, Ms. Alanis, you are able to communicate with the lawyers, including Ms. Leticia Garcia, Elisa Mar Soto, and Madeline Escoto. Do you have any questions for the court, Ms. Alanis?
No, I don't.
Ms. Flores?
Your Honor, would the parties need to be here and present for the May 19th setting?
I would prefer for the parties to be, and
Yes, Your Honor, because if it goes to a full hearing, I'm gonna request that it be not live streamed and the court will be closed because we are gonna be discussing very confidential, sensitive issues about the child.
this is a right. You mentioned live stream, not remote participation. Got it. All right, very good. Anything else?
Nothing further, Judge.
All right. Thank you, Mrs. Cotto. Thank you, Ms.
Thank you,
Soto.
Judge.
You're excused, Ms. Alanis. Have a good day.
Thank you. Bye-bye.
I do have some agreed announcements whenever the court's ready.
Thank you.
Next case in person, Your Honor, the attorney Eustocio Perez, page 1, number 1.
Tanya Elizabeth San Miguel versus Alberto Pina, cause number 2011 CBG 2217C3. Court marks Mr. Perez present in person, Mr. Knotson present in person, Mr. Raul Gonzalez present by video conference. He's here on behalf of the Attorney General's office. Tanya San Miguel. Are you,
Hi.
are you
Yes.
Tanya San Miguel?
Yes.
Welcome to court, Ms. San Miguel. The court marks you present in person. The person to your right is your lawyer. Are you Alberto Pina?
Good morning. Yes, Your Honor.
Welcome to court, Mr. Pina. Court marks you present in person. The person to your right is your lawyer. I'm certainly glad that we can resume this case. Mr. Perez, Mr. Knotson, what is the announcement?
Yes, Judge, we had filed on Friday an emergency motion for the court to appoint a interview of the child by a psychologist with Mrs. Scotto. The prior Jesse Hernandez has seen the child, has a good relationship with her. Basically there, since our last hearing, Judge, there are some extremely serious circumstances that have occurred involving the child, her boyfriend, the mom. The mom has been talking to the child. She's not here today about this case, about the criminal case that a child should not know about. And, you know, basically, we'd like to confer with the court in chambers so we don't have to bring this out on the record, Judge. And we did file through the router system yesterday. My client showed up at my office, brought me some information posted by the child with the boyfriend. You know, there's a lot of issues, you know, it involves, you know, I don't want to say on the record, but, you know, murder, you know, it's very serious, Judge. And Jesse Hernandez told my client to come talk to me immediately. He thought it should be reported to police, but my client didn't want to do that to, you know, have anything happen to the daughter or the boyfriend. And I think it's all because the mom, you know, is concerned about money. And she's telling the child it's all her fault, all because of you. Your grandparents are in debt. It's all because of you.
Your Honor, I object.
And she's extremely stressed.
What is the objection?
Not to testify.
I'm just giving the court an
Well-
overview, the urgency.
The court is going to
of-
make a couple of findings at this juncture. Number
Yes.
one, as to the objection, this isn't evidence, this isn't testimony. Ostensibly, it's just argument. However, second finding, and I'll let you all deal with it however you want. I don't know, obviously, the facts or the circumstances of these new allegations, but I would presume that both counsel, Mr. Knotson and Mr. Perez, know the statutory requirement of reporting issues to law enforcement involving minors. Now, What you do with that situation and your professional judgment is on you. But I don't know at this juncture, without knowing anything else, that this disclosure on the record alleviates any person here from disclosing. Because obviously you haven't done it here to this court at this juncture. So you all figure the facts and circumstances and then make a professional judgment about how best not to violate that statute, if at all.
And I would just ask, you know, if the court would want to talk to the attorneys in chambers. We were talking about a resolution, but this came up, you know, since the last hearing. Also, you know, the child was told that my client's gonna go away indefinitely to jail. That's not the case. That
Again.
and the child said,
So I tell you what, let me just address a couple of things.
yes,
It is exceedingly rare. I can probably count on one hand and have several fingers left over. It is exceedingly rare that this court, under this judge, holds any conferences in chambers. And I'll tell you exactly why. Because number one, if any person, any lawyer discloses to the judge in chambers any factual situation, I can't do anything about it. It's not evidence. It's not testimony. There is nothing I can do. And if I opine on it, it's a very difficult walk, number one. Number two, what I don't want is, I don't want Ms. San Miguel and I don't want Mr. Pina to ever believe that this court and any lawyer, Mr. Knotson, Mr. Perez, or anyone else, can go have a closed door conversation and somehow magically come up with something. My preference, and it is what it is, and it may not be yours, and I'm okay with that, but my preference, Mr. Pina and Ms. San Miguel, is that you either reach an agreement because you know your fact, situation, circumstances, and family history better than any other person. And if you do, I'm likely to say that that is in the best interest of your child. If you can't come to an agreement, the only way for me to make a decision is that I'm going to put you under oath and you get to testify under oath as to what the facts and circumstances are. I take those facts, I apply them to the law, and I give you a result. I don't, this is the only reason why I prefer not to have
I completely understand.
in-person chambers.
Understood. And certainly I or my client don't want to put you in, and we don't have to put that on the record, but I agree with your suggestion. And I will, if you can give us time to confer with Mr. Perez, I believe it's in the best interest of both parties and the child that if they can come to a resolution that they can both live with, I think this will go a long, long way to stabilize the child and move forward on a positive basis. So I'm willing to do that. And Mr. Perez says, with regard to the motion to have her interviewed by the a psychologist, Dr. Jesse Hernandez, he said he'd leave that to your discretion, Judge. So if we can confer first and see if we can come to a resolution, we'll announce that to the court, subject to your approval. If we can't, then we'll need a hearing.
Mr. Perez, response?
I don't believe that the child needs any psychological evaluation. Mr. Norton has stated does not require a psychological evaluation. I believe that the court has an option when children are involved to interview them in chambers. If the court wishes to do that, we suggest that the court do it. Other than that, we're ready to proceed with the hearing.
So do you not want
On,
to?
give me 1 second. Give me 1 second. Don't talk to each other. When you say you're ready to proceed on a hearing, Mr. Perez, do you mean at a final hearing and or a hearing on that emergency motion?
I would say we would need a hearing on the
Perez?
emergency. Oh, I'm
Mr.
sorry.
Perez, you said you were ready to proceed, and I'm just wondering to.
I don't, on the emergency motion first, and I will confirm it with Mr. Norton.
Thank you, Judge.
All right, so talk to each other. I'm gonna mark this as the first contested matter. Ms. San Miguel, Mr. Pina, let me give you some possible outcomes. Either you agree, either you communicate respectfully through your lawyers and reach an agreement that you believe is in the best interest of your child. If you do not, then I'm first gonna consider the emergency motion. If I grant it, this case is gonna take some more time. I can't guarantee that that's gonna be less than 60 days. If I disagree after hearing the arguments and facts, then the court will deny the motion and you'll go into a final hearing and you'll have to live with whatever result the evidence and testimony produces. Do you understand this, Ms. San Miguel?
Yes.
Do you understand this, Mr. Pina?
Yes, Your Honor.
Good luck to you both.
Thank you, Judge.
Next case, Your Honor, is Attorney Madeline Lopez Escoto. This is for the PM docket.
Page and case? Oh.
The De Los Santos case, Judge, that was 2018 FLA 500C3.
Page one, case, well, for the record, this is the 2 p.m. docket. Page 1, case 2, Galinda de los Santos, Eduardo de los Santos, cause number 2018 FLA 500C3. Court marks Mrs. Scotto present in person. Alberto Martinez King, are you present? Court marks counsel not present. Court marks Raul Gonzalez present by video conference. He's here on behalf of the Attorney General's office. Galinda de los Santos, Eduardo de los Santos, are you present? Court marks parties not present. Mrs. Scotto, go ahead.
Judge, I'm pleased to announce that with the assistance of the Associate Judge Leticia Martinez, we were able to resolve this case in its entirety. A mediated settlement agreement was e-filed in this case this morning with Judge Martinez's signature. And I conferred with Mr. King that the court was willing to take announcements today with regards to agreed cases. And so he asked that I announce the settlement. And that the court approved the mediated settlement agreement and that we have an entry date. And obviously, the only person that did not sign it was Catherine Garcia from the OAG because it is their policy not to sign MSAs.
Understood and well taken. Are you asking the court to sign them? You're asking the court to sign the mediated settlement agreement?
I don't think the court needs to.
Oh.
I will attach it as an exhibit A to the order, Judge.
I know Associate Judge Martinez has, I'm told, well, I can see it too, but I've been also told on the record that she has a very good batting average and record on these cases. I don't know what her intent is come January 1, but
We're lucky, Judge.
I'm sure she'll be missed in that situation, in those situations. Well taken. The court has received, reviewed, and considered the mediated settlement agreement. Are you asking for an entry docket date or an order?
Just an entry order date, Judge.
Give us an orders due, please.
By submission, Your Honor?
Yes.
That'll be May 25th at noon by submission.
All right.
And I did, just so Mr. Gonzalez knows, Ms. Garcia wanted us to run the order by her so that she can sign off on the order, Judge.
Your Honor, my apologies. That'll be May 18th at noon by submission.
We stand corrected. May 18th at noon by submission. I congratulate the parties and counsel.
And I have one more, Judge, the Galliano Trad matter.
This is
Page-
page 2, case 5 of the 2 p.m. docket. Bernardo Karim Trad versus Noemi Trad, cause number 2021 FLA 1036C3. Court marks Mrs. Cotto present in person. Juan Jose Garcia, Daniel Walter, are you present? Court finds counsel not present. Bernardo Trad, Noemi Trad. Are the parties present? Court finds parties not present. Counsel, go ahead.
I thought Mr. Walter said he was going to be present, Judge, and that we would announce additional time since he was just hired, but why don't you recall then that one at 2? I don't want to step on his toes.
Sure.
We conferred last night, but
Recall later this morning or at 2?
at 2. Well, let me try calling him, Judge, and that way I can.
All right.
finish that.
Next attorney in person, Your Honor, would be Attorney Eduardo Romero, also for the PM docket.
Mr. Romero, thank you for taking advantage of this morning's availability. What page are
Page
you on?
5, number 12, Your Honor.
This is Ana Cecilia Cisneros Villarreal versus Eduardo Villarreal, cause number 2026 FLA 158C3. Court marks Eduardo Romero present in person. Ana Cecilia Villarreal, Eduardo Villarreal, are you present? Court finds neither party present. Mr. Romero?
Your Honor, the parties have been conferring and finalizing a final decree of divorce. I actually received edits yesterday. I'm just asking for a quick continuance so I can get them sign the final decree and supply the court with an affidavit of jurisdiction, Your Honor.
Well taken. Give us a setting in 2 to 4 weeks, please.
June 2nd at 2 p.m.
You can wait till that day, or if you file something before, happy to consider it before.
Thank you, Your Honor. That's all I have. May I be excused?
Good to see you. Have a great day.
Thank you, Your Honor. Likewise.
Next case is all the PM docket, Your Honor. That'll be Attorney Victor Villafranca, page 5, number 13.
Melissa, good morning. Melissa Michelle Cepeda versus Benigno Gerardo Cepeda, cause number 2026 FLA 391C3. Court marks Mr. Villafranca present in person, Mr. Gonzalez also present in person. Speak into the microphone as close to the microphone as possible and tell the court, are you Melissa Michelle Cepeda?
Yes.
Welcome to court, Ms. Cepeda. The court marks you present in person. The person to your right is your lawyer. Are you Benigno Gerardo Cepeda?
That is correct, Your Honor.
Welcome to court, Mr. Cepeda. Court marks you present in person. The person to your right is your lawyer, Mr. Villafranca. Mr. Gonzalez, go ahead.
Your Honor, we're here for temporary order, restraining order was filed by, counsel, and we have come to an agreement, Judge.
That is correct. Your Honor.
Will you be putting it in writing, or do you want to read it into the record?
Your Honor, I had submitted it, for the record, it's just a couple of amendments, I guess, or additions. We can read it into the record, or if you want me to resubmit it.
Recommend for it to be read into the record, Judge, and then we'll look over the order,
It was filed.
I e-filed.
Let me hear from the clerk's office.
If I may, Your Honor, it has not been filed.
temporary restraining order was filed, Judge, but the agreed orders we have not, submitted yet. We'll come up with
That is
agreed
correct.
orders. We'll put that-
Oh, I see. Yeah, yes, please read the agreement into the record.
So, Your Honor, we did agree that the counter petitioner would be awarded the exclusive use and enjoyment of the residence located at 2139 Lima Loop, Laredo, Texas 78045 during periods of possession of the child. It's going to be extended standard possessions on it. And with no unrelated female allowed to be at the residence during times of possession. The counter petitioner will be awarded exclusive use and control of the 2007 Ford Mustang and 2005 Ford F-150. And counter respondent should be enjoined from entering and operating or exercise control over him. Counter petitioner, counter respondent should be appointed temporary joint managing conservators with counter respondent being able to select the place of residence. The court should order reasonable periods of electronic communication between the child and counter petitioner. The counter respondent shall maintain and care for the 2021 Dodge Durango. The primary residence of the child should be restricted to Webb County. Counter respondent should be enjoined from removing the child beyond Webb County. And basically, the mail pickup will be allowed once a week. At
The what pickup?
mail, any mail.
Oh, I see.
Your Honor, we did also come to an agreement that all bills and mortgage status quo would be paid. And therefore, we're not asking for any child support at this time.
That is correct.
Any other portion of the agreement, Mr. Villafranca?
No, Your
Mr. Gonzalez?
Nothing, Your Honor.
Ms. Cepeda, Mr. Cepeda, I'm gonna ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth? So help you God?
I do.
Both have answered yes. You may lower your hands. Let me begin by asking you, Ms. Cepeda, get close to the microphone, please. I'm gonna begin by asking you, because you're the petitioner in this case. Is your true and correct name Melissa Michelle Cepeda?
Yes.
Ms. Cepeda, did you hear and understand the agreement that was told to the court by the lawyers?
I do.
These are only temporary agreements, but is this agreement your full agreement?
Yes.
Is there anything you want to change? Anything left out?
No.
Do you believe that this agreement is in the best interest of your child or children?
Yes, I do.
Same questions to you, Mr. Cepeda. Is your true and correct name Benigno Gerardo Cepeda?
It is.
Mr. Cepeda, did you hear and understand the agreement that was told to the court by the lawyers?
I did.
This is only a temporary agreement, but is that your agreement with Ms. Cepeda? Is
It is.
that your full agreement?
Yes.
Anything left out?
No, sir.
Is there anything you want to change?
No, sir.
Do you believe that this agreement is in the best interest of your child or children?
It is, Your Honor.
Ms. Cepeda, Mr. Cepeda, the court hereby approves your agreement and finds that it is in the best interest at this juncture. These are the temporary orders to the court. These are the temporary orders of the court. These orders are due to the court on or before.
May eighteenth at noon by submission.
Do you have any questions for the court, Ms. Cepeda?
No, I don't.
Do you have any questions for the court, Mr. Cepeda?
No, sir.
So follow these court orders between now and June the 4th at 2. You'll come back on that day, either with an agreement. If you don't have an agreement, I'll put you under oath. You'll tell the court your situation and facts, and I'll make a decision for you. I wish you both very well. Have a
Thank you.
good day.
Thank
care.
you.
Good to see you.
Yes, sir. Have a great day.
Next case, Your Honor, in person is Attorney Nathan Chu, page 3, number 7.
Miguel Angel Cuenca versus Brenda Marie Cuenca, cause number 2025 FLA 1624C3. Court marks Mr. Chu present in person, Mr. Raul Gonzalez present and participating by video conference on behalf of the Attorney General's office.
Good morning. Press for Ms. Cuenca. Your Honor, can we put us on recall? I think Mr. Bundio Cantu is at the DA's office. I have to go grab.
Understood. Are you Brenda Marie Cuenca? Court has heard yes. Welcome to court, Ms. Cuenca. The court marks you present in person. The person to your left is your lawyer. Are you Miguel Angel Cuenca?
Yes.
Welcome to court, Mr. Cuenca. The court marks you present in person. Your lawyer isn't present here, but Mr. Chu, Ms. Cuenca's lawyer, says that he is next door at the district attorney's office. So I'm going to place your case on hold, and I'll call your case momentarily. Stand by, please.
Thank you, Judge.
Next case, Attorney Brenda Anderson, page 4, number 10.
Iris Pisana versus Andres Alejandro Ramon, cause number 2026 FLA 131C3. Court marks Ms. Anderson present by video conference. Good morning,
morning,
Ms.
Judge.
Anderson. Iris Pisana Andres Alejandro Ramon. Any parties present?
I don't think so, Your Honor.
Mr. Ramon, I'm going to ask that you start your video and you turn on your microphone. Are you Andres Ramon?
Yes, sir. Good morning, Judge.
Good morning, Mr. Ramon. The court marks you present. You're participating by video conference. Mr. Ramon, do you have a lawyer?
No, sir.
Are you going forward without a lawyer?
Yes, sir.
Court marks you self-represented. One more time. Iris Pisana, are you present? Court marks Ms. Pisana not present. Ms. Anderson, go ahead.
Your Honor, the parties have reached an agreement in this case, and I did prepare an agreed final decree of divorce that both parties have signed. And I also have e-filed a proof of affidavit signed by my client.
Mr. Ramon, the court has received an agreed to final decree of divorce. It is signed by all parties and there is an affidavit stipulating to the jurisdiction of the court. Is there anything that you would like to say?
No, sir.
Are you asking the court to approve your agreement?
Yes, sir.
Mr. Ramon, in your case, cause number 2026 FLA 131C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage with Iris Pisana. Unfortunately, that marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends in the marriage relationship. The court finds that there was one child, a female, that was born in the marriage. No other children were born, adopted, or are expected. The court finds that you have an agreement regarding your child. The court hereby adopts and approves that agreement and finds that it is, in fact, in her best interest. The court also finds that you have an agreement regarding the division of your property. The court hereby adopts and approves it by agreement and finds that your agreement is, in fact, and effectuates a just and right division. The court at this time, Mr. Ramon, finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced.
Thank you, Your Honor.
Thank
The
you,
court
Judge.
has considered that final decree of divorce. I have signed it, and I am tendering the original signed copy to our coordinator. That concludes your case. Mr. Ramon, do you have any questions for the court?
No, sir.
I wish you, Ms. Pisana, and your daughter all the best. Good luck to you, sir.
Thank you.
Thank you,
Judge.
sir.
Any other
Your
cases
Honor,
for Ms.
Yes,
Anderson?
yes, Your Honor, that'll be page 5, number 12.
Alfonso Hinojosa Jr. versus Erika Rubi Garcia, cause number 2026 FLC 106C3. Court marks Ms. Anderson present by video conference, Ms. Leticia Garcia present by video conference, Ms. Raul Gonzalez present by video conference on behalf of the Attorney General's office. Alfonso Hinojosa Jr., Erika Rubi Garcia. Any other persons present? Court finds no other persons present. Ms. Anderson, Ms. Garcia, go ahead.
Your Honor, in this case,
Go ahead, Brenda.
in this case, Judge, the parties have gone to get paternity testing with the AG's office. I understood my client went last Friday with the child, and dad had gone previously. So we're just pending the results.
Your Honor, also I did file an amended order for genetic testing just to reflect DDC through the Attorney General's office, which we were thankfully allowed to get tested through them based on their motion for intervention. So if the court would sign that off, I think it would clear up any matters with regards to the docket. And I suppose we already have a final date, Judge. I think we're in June for TOM. So to that end, I think we're on track.
Ms. Anderson, have you seen, reviewed, considered, and have any objections to the amended order for genetic testing?
I have no objections. I've reviewed it.
Ms. Garcia, Ms. Anderson, you're set on June the 2nd. Is that sufficient time for the parties to be tested with results?
Yes, Judge, I do think so. All three parties, father, mother, and child, have been tested. So the Attorney General's office works pretty quickly. I suggest we just kind of sit on it and wait for that date, Judge.
I agree, Judge.
Anything to add, Mr. Gonzalez?
No, Your Honor.
Well taken on all fronts. The court has signed that amended order, tendering the original to the coordinator for this docket, and we'll come back on June the 2nd. Ms. Garcia, Ms. Anderson, Mr. Gonzalez, thank you all very much.
Thank you, Judge.
Okay.
Judge, I am appearing on a case from the afternoon docket with
All right.
Miss Claudia Lanese.
I think I saw her device
Yes.
logged in. Page and
Yes,
case.
good morning, Judge.
6, number 15.
This is Maria de Lourdes Johnson Contreras versus Mario Alberto Ortiz, cause number 2026 FLF 69C3. Court marks Ms. Anderson present and participating by video conference. Ms. Claudia Garcia present by video conference as well. Mr. Raul Gonzalez present by video conference. He's here on behalf of the Attorney General's office. Maria de Lourdes Johnson Contreras, Mario Alberto Ortiz. Any parties present?
No,
Court
Judge.
Court finds no parties present. Ms. Garcia, go ahead.
It was set for trial on the merits today, and just a brief encapsulation. I represent Maria de Lourdes Johnson. She has guardianship of these two grandsons. The youngest one, who is about 5, has no alleged father. They know no information about any biological father. Mario Alberto Ortiz has a father who has never paid a dime of child support, and I will get with the Attorney General to see what we do about that. He has been served. He has not made any answer, and I will let the court know in the guardianship proceedings. We had guardianship proceedings, Judge, because their mother tragically passed away in a terrible car accident with her other son, their other brother. So she has guardianship of the person and estate of these boys because there is some money coming to them in some form of settlements. My client does want to adopt the children. It's just easier than maintaining a guardianship. The oldest has never had a relationship with his father whatsoever. The father showed up at the guardianship hearing and gave his consent to my client being the guardian of Mario Alberto. Having said all that, Ms. Anderson assisted in the guardianship proceedings, Judge, so she is familiar with the children. She's not had the opportunity to talk to them about this adoption, termination and adoption by their grandmother, so we just need a little extra time. And that way I can also talk with the Attorney General, because we may not want to give up that child support right for Mario Alberto.
Just a question and a couple of thoughts, just to contemplate,
Yes.
and all the points are well taken. We'll give another date.
Mhm.
First thought, I see that the guardianship is cause number 2023 PD 6101 L1.
Yes.
First question, I guess the only question I have is, you said that it is possible that Ms. Contreras will be seeking adoption of these children.
Well, client is seeking adoption of these children. Ms. Johnson, yes. Mhm.
If this court grants the adoption, what effect, if any, does it have on the guardianship in County 1?
Guardianship of the person will be gone. Guardianship of the estate, we just need to wrap up because there is, Ms. Anderson is actually the ad litem for Mario Alberto in a settlement proceeding pending in the 406. And that's a small insurance policy. And we're working on another one, Judge. So that could continue. Mario is, I think, 15 or 16, Judge. But it's just most helpful. It's a lot of money to be in guardianship. So if there's an opportunity, and then the smallest one, Mateo or Matias, Mateo, he's 5 years old. It's a long time to be under guardianship, with having to do reports and things like that. So it's just, when we talk about least restrictive alternative, I believe that she could still have the mother's death benefits with Social Security, even if she adopts. That's what we've been looking, just to make sure that she doesn't lose that for the best interest of the littlest one, especially because it's many, many years. But because it's a grandparent adoption, it shouldn't be a problem. And he has no alleged father, nothing, absolutely nothing.
All points well taken. How much time would be reasonable and necessary to set that final hearing?
I would ask for a couple of months because I do need to speak with the Attorney General with regard to that very old child support case with regard to Mario, who's alive, and Maximiliano, who passed away.
The court will grant a setting in July, Ms. Flores?
July the 9th at 2 p.m.
Now, I said I had a question and a comment.
Yes.
Here's my comment. And you don't have to do this. It's just, I think everybody knows my judicial philosophy and style, but if it were me, so County Court at Law 1 has a guardianship, County Court at Law 2 has both, all the family related stuff. So both the AG case and the adoption.
Correct.
I highly suggest, and you don't have to, it's just, there's good ways and better ways to do things, but I suggest that they all transfer one way or all transfer the other way. That way, because I always tell people on, at least on the criminal law docket, first time I mentioned it in the family law docket, but when people have criminal cases in several courts, they really don't care if they have two judges and several sets of lawyers. They're only just one set of persons. So same thing in this situation. If you have one court, because both courts have jurisdiction over both, if you have one court to oversee both the guardianship and the family law case, and I'm not fishing for send it or keep it, either one, I think judges Martinez and I would be happy to do either one.
Yes, obviously I had to file it here because there was a prior Attorney General case, but I will talk to my client about that, and I think that's a good idea.
Happy to keep it, happy to send it, whatever is in the best interest of justice, and happy to have no action taken either way, so.
Okay, and I'll talk to the Attorney General about it as well.
Sure, all right.
Okay, all right.
Ms. Anderson, anything to add?
No, Your Honor.
Mr. Gonzalez?
No, Your Honor.
All right, we'll call this case on to, oh, the only thing that I would ask Ms. Garcia, if you do contemplate sending the guardianship, asking that the guardianship be sent here or asking that the family case be sent there, just please do that sometime in June so that ready to go in one
Right.
court in July.
Will do so. Thank you, Judge.
All right, good luck.
Thank you.
Thank you,
May I be
Judge.
excused?
Yes, have a good day.
May I be excused too, Judge? That's all I
Yes.
have.
Have a good day.
Thank you. You
Next
too.
case in person, Your Honor, would be Attorney Madeline Lopez Escoto for the afternoon docket. Page 2, number 5.
This is Bernardo Karim Trad versus Noemi Trad, cause number 2021 FLA 10363. Court marks Ms. Lopez Escoto present in person. Mr. Daniel Walter also present in person. Parties are not present. Counsel, what is the announcement?
Judge Madeline Escoto for now, Naomi Galliano. Judge, it's my understanding that Mr. Walters was just recently hired. I do not have an objection to his motion for substitution.
Mr. Walter, are you urging this?
That's correct, Your Honor. I'm substituting in for, I believe it's, JJ Garcia, Attorney JJ Garcia, and, on behalf of my client's request, and, I just needed some extra time for any motions that I said today. And I think we're gonna.
I'm gonna confer with him, Judge, on my motion for the ad litem and the social study, and hopefully we can get that by agreement. And then possibly come back for we don't have temporary orders in this case, Judge, so
All right, let me take this one step at a time. So as to the substitution, the court sees there's no objection, but I need another order filed.
Absolutely.
This order is titled motion, and then it grants the motion and then sets that it's not going to be set no sooner than 14 days. I would just leave it blank so that we can just set in a.
We'll do good.
So court grants a substitution. It is well taken, not objected to. Those orders are due to the court honor before.
May the 18th at noon by submission.
All right. And now, pardon me, and now you were saying.
we're going to confer, Judge, with regards to the appointment of the guardian ad litem and the social study. So if the court can give us time for that. And then we were set for a temporary orders hearing. Obviously, we can't have it since Mr. Walters was just retained. If the court can just give us maybe a date, late May, early June.
Any objection?
Absolutely not.
Give us that date, please, Ms. Flores.
Yeah.
June 2nd at 2 p.m.
So these are temporary orders, the motion for the appointment of a guardian ad litem and the motion for the, so everything that is on file is hereby set for June the 6th, and that includes that motion for child custody evaluation. If you have an agreement,
I think she said June 2nd.
I'm sorry, did I not say that?
You said you said June 6th.
I'm reading, I'm reading numbers. I apologize.
I'm confused.
June the 2nd at 2 p.m.
Okay.
All right, welcome on board, Mr. Walter. I'll send that order as soon as it comes in. Thank you, Mr. Walter. Thank you, Mr. Scott. I'll call this case on June the 2nd.
Thank you. And if I can be excused till 2.
Have a
Thank you,
great day.
Judge.
Yes.
Thank you.
Yes, have a great day.
Thank you.
Good to see you.
Next case, Your Honor, is Attorney Juan Jose Garcia, page 4, number 11.
Adriana Agustin Torres versus Victor Hugo Torres Padron, cause number 2026 FLB 281C3. Good morning, Mr. Garcia.
Good morning, Your Honor.
Court marks you present by video conference. Adriana Torres, Victor Hugo Torres Padron, are you present?
Yes.
Are you Adriana Agustin Torres?
Yeah.
We'll begin Spanish language interpretation now. Are you Adriana Agustin Torres?
Yes.
Welcome to court, Ms. Torres. You're joining us in person. As you can see from this screen and device, your lawyer is present and participating by video conference. Victor Hugo Torres Padron, are you present? Court finds respondent Torres Padron not present. Mr. Garcia, what is the announcement?
In this case, Your Honor, I filed the motion for substituted service.
Does the clerk have that motion in order?
Yes, Your Honor. 1 second.
A quick question, Mr. Garcia. I find that there is sufficient information in the supporting affidavit to grant the request. But I need to ask, the request to publish in the Laredo Morning Times versus posting it at the courthouse doors or at the courthouse? Any preference for either or both?
It could be either or, Your Honor. It could also be at the courthouse.
I think given the contents of the affidavit, in this case, the court is going to order both. So there is absolutely definitively no issue with service. Ms. Torres, the court has granted your request. Substituted service is granted by publication and posting. We'll come back for a final hearing in 45 days. Ms. Flores.
June 18th at 9 a.m.
If I may, Your Honor,
Yes.
District Clerk's Office speaking. Because there's a statement of inability on file, we wouldn't issue it out to be published with LMT. We would issue it and post it on the OCA website.
That sounds perfect. All right. Ms. Torres, you'll come back for your hearing on June the 18th, not on May the 19th. Do you have any questions for the court?
No.
Anything else on this case, Mr. Garcia?
No, Your Honor.
Good luck to you, Ms. Torres. Other cases for Mr. Garcia?
Yes, Your Honor, that'll be page 5, number 13.
Alejandra Baby Guerrero versus Roy Alejandro Guerrero, cause number 2026 FLG 593C3. Court marks Mr. Garcia present by video conference, Mr. Chu present in person. Alejandra Guerrero, are you present?
Good morning, Judge. This is Chu present for Miss Alejandra Guerrero.
Your Honor, I'm present.
Welcome to court, Ms. Guerrero. The court marks you present in person. The person to your right is your lawyer, Roy Alejandro Guerrero. Are you present? Court finds Mr. Guerrero not present. Mr. Chu, Mr. Garcia, what is the announcement?
Judge, we're here for the protective order. I've been informed by Mr. Garcia that Mr. Garcia does not represent Mr. Guerrero for the protective order.
That's correct, Your Honor. I only represent him on the divorce.
Understood. Court does not mark you present on this case. Court marks Mr. Guerrero not present, and the court takes judicial notice that he was served with process in this matter on April 27, 2026. Mr. Chu, are you ready to proceed?
Yes, Your Honor.
Ms. Guerrero, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand, Mr. Chu.
May it please the court, would you please state your full name for the record?
Alejandra Baby Guerrero.
And Mrs. Guerrero, are you married to Mr. Roy Alexander Guerrero?
Yes.
And do you have a child with Mr. Guerrero?
Yes.
Okay. And Mrs. Guerrero, what happened to you on December 27th of 2024 with Mr. Guerrero?
He was coming back for a holiday block leave from the military. Like they got vacation days. And we had an argument while we were in his room in his parents' house. And then he had grabbed my wrist and slammed me into the floor in front of our child.
Okay. And then on or about April of 2025, what did he do? What did Mr. Guerrero do to you?
Well, we had just moved to El Paso and we had an argument and it led to him picking me up and throwing me across the room.
Okay. And what about July 4th of 2025, Mrs. Guerrero?
July 4th, it was the 4th of July, so he got like holiday days again. And we came to visit Laredo. And while we were here, we had an argument and I just stayed in Laredo while he left back to El Paso.
Okay. And then on September 16th of 2025?
He was visiting again because it was the week that our son was going to turn 2. And I had left work at around 9:30 p.m. and he had showed up to my work at around 10 p.m. with our son who was sick, and he stayed outside my place of employment for 2 hours. Just waiting for me to get out, but I had already left.
Okay. So Mr. Guerrero has assaulted you. And so you fear that he's around you and your child, is that correct?
Yes.
And you're asking the court for the protection?
Yes.
And you're asking the court for up to 2 years of the protection against Mr. Guerrero?
Yes.
And also for your child also, right?
Yes.
Okay. You also asked the court to not allow Mr. Guerrero to come within 200 yards of your home. Is that right?
Yes.
And what is your house address?
It's 5120 San Francisco Avenue.
That's located here in Laredo, Texas?
Yes.
You're also asking the court to not allow Mr. Guerrero to come within 200 yards of your workplace, is that correct?
Yes.
Where do you work, Mrs. Guerrero?
It's 1902 Bubbly Group. It's Olive Garden.
Okay. Um, And you said you also asked the court to not allow Mr. Guerrero to come close to your child, is that right?
Yes.
And if there is any visits later on determined, it'll be supervised
Yes.
at a safe place, is that right?
Yes.
Okay. That's all we have here.
Ms. Guerrero, in your case, cause number 2026 FLG 593C3, the court at this time finds that it has jurisdiction over your case. The court has now under oath heard your evidence and testimony. The court finds that there is sufficient information and facts and evidence in the record to permit the court to grant your request. The court hereby grants your request and will cause a protective order to be issued out for the period of 2 years as requested. The court finds that there is sufficient grounds, reason, and basis to make this request and to grant it as well. These are the orders of the court, and the orders are due to the court honor before
May 18 at noon by submission.
have any questions for the court, Ms. Guerrero?
No.
I wish you well.
Thank you, Judge.
Any other cases for Mr. Chu?
Yes, Your Honor, that'll be page 3, number 7.
Miguel Ángel Cuenca versus Brenda Marie Cuenca, cause number 2025 FLA 1624C3. Court marks Mr. Cantu, Rene Cantu present in person, Mr. Chu also present in person. Are you Brenda Marie Cuenca?
Yes.
You're in person, your lawyer's on your right. Are you Miguel Ángel Cuenca?
Yes, Your Honor.
You're in person, your lawyer's on your left. Counsel, what is the announcement?
Judge, we do have an agreement of for the final divorce today, Your Honor.
That's correct, Judge.
Would you like to prove it up or just put it on the record and I'll ask some questions? Ms. Cuenca, Mr. Cuenca, would you both raise your right hands? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Yes.
Both have answered yes. You may lower your hands. Speak really loudly into the microphone as your lawyers ask you some questions. Counsel, go ahead.
May it please the court. Would you state your full name for the record?
Brenda Marie Cuenca.
And you were married to Mr. Miguel Angel Cuenca?
Yes.
And from the marriage, you have 3 children, Miguel Angel Cuenca Jr., Brandon Morris Cuenca, and Marie Angel Cuenca. Is that right?
Yes.
And you were married here in Laredo, Texas?
Yes.
When were you married, Ms. Cuenca?
December 14 of 2007.
Now, as part of the agreement, you and Mr. Cuenca are going to be named joint managing conservators, conservator of the children. Is that right?
Yes.
Okay. And with you having the primary right to decide where the children reside.
Yes.
And the children reside with you.
Yes.
You
Let me ask court staff, is Ms. Cuenca audible?
Yes, Judge.
All right, go ahead.
And you've also agreed to child support in the amount of $1,300. Is that right?
Yes.
And that's going to begin on June 1st.
Yes.
Okay. You've also agreed on standard visitation.
Yes.
Okay. You also understand that Mr. Cuenca can also elect extended standard, which means that he will pick up if he elects it, then he'll pick up the children on Thursday when school release and return the children Monday morning when school resumes.
Yes.
If he doesn't, then his visitation will start Friday at 6 p.m. and return Sunday at 6 p.m.
Yeah.
Okay. There is a family home that is located at 5522 Stallion Lane. Is that right?
Yes.
And you've agreed with Mr. Cuenca to put up the family home for sale.
Yes.
And the proceeds to be divided evenly 50-50.
Yes.
Okay. There is also Mr. Cuenca has a retirement from PepsiCo. Is that right?
Yes.
And taking into account the current balance right now is at $47,672. Is that right?
Yes.
There is a loan that was taken out to improve the home in the amount of $15,543. Is that right?
Yes.
So the balance left is $32,129.
Yes.
So your half of it would be $16,065. Is that right?
Yes.
And you've also agreed that any debts that you have will be split between you and Mr. Cuenca.
Yeah.
Okay, and Ms. Cuenca, I need to ask you this, are you pregnant or expecting a child anytime right now with Mr. Cuenca?
No.
Okay, and do you want the divorce?
Yeah.
Is there any chance of you reconciling and getting together with Mr. Cuenca?
No.
And do you believe that this agreement is in the best interest of your children?
Mm.
Pass the witness.
Any questions for Ms. Cuenca, Mr. Cantu?
Yes, Ron, I just have just one quick question. Miss Cuenca, are you requesting a name change?
Yes.
And that name change is to Brenda Marie Morales, is that correct?
Correct.
Okay. I'll pass the witness.
Any other questions for your client, Mr. Chu?
No questions.
Questions for your client, Mr. Cantu?
Yes, Ron, just a few quick questions. Mr. Cuenca, you heard the agreement that was read by Mr. Chu, is that correct?
Yes,
And that agreement is essentially the same agreement that you and I discussed today, is that correct?
correct.
Are you in agreement with all the terms that he read?
Yes,
And you understand that you'll begin paying child support on June 1st of 2026?
yes,
And that amount, just to confirm, would be 1,300 for the benefit of your children, is that correct?
correct.
Okay. And you also understand that the home will be put immediately up for sale? You're in agreement with that, correct?
Yes,
And any proceeds left over, that'll be split 50-50 between you and Mrs. Cuenca, now known as Ms. Morales, is that correct?
correct.
Okay. Do you have any questions about anything we discussed today?
No,
Are you asking the judge to approve this divorce, and do you believe it's in the best interest of your children and of the marriage?
yes.
That's all I have for you, Judge.
Any cross-examination questions for Mr. Cuenca, Mr. Chu?
No, Judge.
Mr. Gonzalez, any questions for either party?
Yes, Your Honor. I do have
Go
a
ahead.
couple of questions.
Go ahead.
The first thing is regarding insurance, or either of the parties carrying private or employer-based insurance.
The kids have insurance and I provide that to my employee.
Perfect. And regarding, I do see a request for non-disclosure. Is that going to continue? And if so, is the pickup and drop-offs going to be in a public location?
Yeah, I can pick them up at
the house.
At the house is fine, Judge.
All right.
And then we'll drop the request for the non-disclosure.
Perfect. That's all for me, Your Honor. Thank you.
Anything else from any side?
We
Okay.
rest, we rest.
Just a couple of questions. Ms. Cuenca, you filed this action, this case for divorce, November 17, 2025. On that date, had you lived in Texas for 6 months?
Yeah.
Had you lived in Webb County for 90 days?
Yeah.
Court heard the agreement that you have with Mr. Cuenca regarding the division of your property. Do you believe that that is a just and right division?
Yeah.
Same question to you, Mr. Cuenca. You heard the lawyers tell the court what your agreement with Ms. Cuenca is regarding the division of your property. Do you believe that your agreement on the division of your property is a just and right division?
Yes, Your Honor.
All right. Mr. Cuenca, Ms. Cuenca. Oh, Mr. Cuenca, you're the petitioner. I'm sorry. Mr. Cuenca, you filed this divorce November 17, 2025. On that date, had you lived in Texas for 6 months?
Yes,
Had you lived in Webb County for 90 days?
yes.
All right. Mr. Cuenca, Ms. Cuenca, in your case, cause number 2025 FLA 1624C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage. Unfortunately, that marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 3 children born in the marriage. No other children were born, adopted, or are expected. The court finds that you have an agreement regarding your children. The court hereby adopts and approves your agreement in full and finds that it is, in fact, in their best interest. The court also finds that you have an agreement regarding the division of your property. The court hereby adopts and approves your agreement and finds that it is a just and right division. Ms. Cuenca, the court hereby changes your name to Brenda Marie Morales. And at this time, Mr. Cuenca and Ms. Morales, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due on or before
May 18 at noon by submission.
Do you have any questions for the court, Mr. Cuenca?
No.
Do you have any questions for the court, Ms. Morales?
No.
Mr. Cantu,
No, Judge. Thank you.
Mr. Chu, Mr. Gonzalez,
No, Your Honor.
Mr. Cuenca, and Ms. Morales, I wish you both well. More importantly, I wish your three children all the best. Good luck to everyone.
Thank you.
Thank you.
Yes, Judge. Thank you, Judge. May we excuse your honor.
Good to
Yes,
see you
thank you,
both.
Judge.
Good seeing you, Judge. Thank
We'll
you.
see you this afternoon.
Yes, sir.
Next case, Attorney Leticia Garcia, page 2 and 3, numbers 5 and 6.
Sir, companion case is Alicia Karina Barzola versus Luis Arturo Arriaga, cause number 2023 FLI 681C3 and 2025 FLA 1647C3. Court marks Ms. Leticia Garcia present by video conference, Mr. Oscar Verla also present and participating by video conference, Mr. Raul Gonzalez by video conference on behalf of the Attorney General's office. Mr. Vela, is this Luis Arriaga behind you?
Yes, Judge. He's present in my office.
Mr. Arriaga, welcome to court. The court marks you present by video conference from the office of your lawyer. Alicia Barzola, are you present? Court finds Ms. Barzola not present. Ms. Garcia, Mr. Vela, go ahead.
Good morning, Your Honor. Leticia Garcia for Alicia Barzola. She has been in the well, Judge, and in case I cut off, I'm having some video difficulties, Judge. In case I freeze, it's not by choice. But I filed a continuance, Judge, on settings that we have, companion cases. Mr. Vela and I, SAPSER filed on behalf of Mr. Vela and myself a divorce. For the reason, and it's just a little bit complicated. My client was, as I set out in my motion, Your Honor, summoned to an immigration court. She's got court on June the 8th after the last pause of this immigration proceeding in 2022. And literally the first week of this past month of April, she was summoned to court on the 15th, being the first time from 2022. It concerns some complicated issues, Judge, regarding her residency, none of which is based on any wrongdoing on her part. But nevertheless, for that reason, Judge, I'm asking for a continuance. On both cases, we did agree previously to consolidate this matter, Judge. I think that the order might not have been signed yet, even though I think Mr. Vela did file one. But I am requesting just a short pass. The next hearing for her immigration court is June the 8th. Their daughter graduates here in Laredo, their oldest daughter, on the 22nd of this month. And for those two reasons, Judge, I am requesting perhaps a date very shortly after June 8th, perhaps maybe the end of June, maybe the very beginning of July, so that we can be more apprised of what information my client gathers from that particular hearing. And it's unopposed by Mr. Vela. Unopposed, though.
Mr. Vela?
Yes, Judge, that's correct. The only thing I want to advise the court is that this case involves an issue whether there is a informal marriage, and it involves a piece of property, Judge, that currently Ms. Barzola is residing in and is required to make the payments. I have advised Ms. Garcia that the payments have not been made on time and the note is under my client's name, and that's affecting my client's interest. So we need to resolve this case in June after the June 8th hearing that she has. So if the court could please give us a date in mid-June so that we could bring conclusion to this case.
Any objection to a mid-June setting, Ms. Garcia?
Absolutely not, Your Honor. Perhaps if the court has it that maybe the last week of June at the earliest, just so that we can get maybe an order from the immigration court in writing for purposes of our two proceedings here in this particular court, just so we can all be apprised of any other orders that might pertain to the issues in the modification and the divorce that we have, possible divorce.
Mr. Vela?
That's correct, Judge. That's fine.
All right, Ms. Flores. First question to the clerk's office. Is there an order consolidating the cases?
No, Your Honor, the order that was filed with the motion to consolidate was an order of continuance. Yeah.
All right, so let me set this for orders to on that order for consolidation. That order is due to the court honor before.
May 18th at noon by submission.
And we'll come back on both cases ostensibly. Oh, Mr. Gonzalez, I apologize. Before I do that, would you like to be heard?
I'm good, Your Honor. Thank you.
Thanks. All right, we'll come back in mid to late June as requested, Ms. Flores.
Yes, Your Honor, last day in June would be June 18th at 9 a.m.
All right, so ordered. Anything else on this case, Ms. Garcia?
Your Honor, by chance, is there any other date the next week? The hearing for the immigration court is on the 8th. I'm not sure whether a transcript or a final order would be available by 10 days later. And her immigration attorneys are in San Antonio. I'm trying to think in advance, perhaps maybe the last week of June.
Well, I don't mind granting you the last weekend, but see, the family law setting is a self-represented litigant day. I don't mind you all appearing on that day, Mr. Vela, Ms. Garcia, but you're going to be surrounded by self-represented cases.
If we could, Judge, if we could keep the 18th, Ms. Garcia, I would advise her that the immigration court issues its orders on the same day that it has a hearing. They're very fast. And so we'll have an order by the 8th, whatever happens.
And so, yeah. I also have the first full week in July. But you all tell me if that works or that doesn't work.
Judge, if Mr. Vela is unable to agree to the first week of July, I understand, and we can take the 18th with fingers crossed. Hopefully we have enough time in perhaps a 9-day period to maybe, send and receive offers of proposal for the settlement of this case. We had intended, Judge, to perhaps go for an informal mediation with Judge Letty in the event that we would need it. Clearly, there are issues that now are affected directly with what might be this ruling of this immigration court. It goes to the crux of everything, Judge, and it is very significant and emotional for my client at this point of time. Out of the clear blue sky, this 1 month of April, she's literally been in the country for over 20 years, Judge, working with no issues, no problems. So unless the first week of July is unavailable with Mr. Vela, the 18th would be sufficient, I suppose, Judge.
Judge, I understand Ms. Garcia's concern. I do have another case on July 1st with this court. And so if you have a date on July 1st, I could appear on that day to give Ms. Garcia an extra 2 weeks.
Thank you, Mr. Vela.
And we could ask if Judge Leticia Martinez would give us an informal mediation date with her so that we could try to get through some of the issues, Judge.
Thank you, Mr. Vela.
Well, oddly enough, the only date between now and June the 18th that she has available is next Monday, May the 11th. I don't know that you all would be ready or available.
Judge, no, I'm requesting something perhaps after June the 8th.
She doesn't have anything.
Mr. Vela,
she does, but they're taken. She's completely booked.
Judge, we can work on potentially getting a private mediator just for a half day. And that way we don't have to burden the court with with another setting.
All right, let me leave this on for June the 18th. If you need another date, I'm happy to hear out what the situation is. We're gonna come back to court on June the 18th at 9. Ms. Barsola, the court marks you present and participating by video conference. Ms. Barsola, do you have any questions for the court?
No, Your Honor.
Mr. Arriaga, you'll come back to court on June the 18th at 9. Do you have any questions?
No, sir.
Court is certain no. All right, keep in contact with your lawyers. Anything else on this case, Mr. Gonzalez?
Yeah.
Mr. Vela?
No, Judge.
Ms. Garcia?
Nothing, Your Honor. Thank you. And thank you, Mr. Vela.
Good luck to everyone. You're
Thank-
excused.
Thank you, counsel.
Thank you, Your Honor.
Thank you.
Mr. Vela has
Maybe-
another question, so does Ms. Garcia, Your Honor.
Ah,
Ms. Garcia is on page 4, number 9, the item.
Juan Antonio Lesa versus Linda Sanchez, cause number 2025 FLI 281C3. Court marks Ms. Garcia present by video conference. Mr. Raul Gonzalez present by video conference. He's here on behalf of the Attorney General's office. Javier Guzman, Julia Rubio, are you present? Court finds neither counsel present. Juan Antonio Lesa, Linda Sanchez, are you present? Court finds parties not present.
Your Honor, if I may, to that end, Ms. Garcia, guardian ad litem, I know that Mr. Guzman had filed a couple of letters advising the court, from what I can see, of his necessity to be in another court. And I think we were set for a final pretrial and perhaps an entry of a request for a social study by Dr. Galvan. That's all I know at this particular time. I think Mr. Guzman might have filed a second letter yesterday or this morning that he has got a criminal setting. But I can reach out to both of them, Judge. If not, we can just log on this afternoon. Hi, Juan.
Hello.
Hi, Judge, I'm here.
Court, excuse me?
I'm here, Judge, I'm present. Javier Guzman.
Mr. Guzman, welcome to court. The court marks you present. You're participating by video conference. I was just reviewing the docket sheet for the criminal case. All right, court marks Mr. Guzman present by video conference. Ms. Julia Rubio not present. Are you Juan Lesa?
Yes, sir.
Welcome to court. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Linda Sanchez, are you present? Court finds respondent Sanchez not present. Mr. Guzman, what is the announcement?
Yes, Judge. So first of all, Ms. Rubio was under the impression that we were supposed to be here at 2. So I went in, I checked in person, but we're set just for a request for a child custody evaluation to be done. This case is headed to a jury trial, Judge. And so we would like for a child custody evaluator to be appointed. If Your Honor would prefer me to get back online at 2, I can do that. Again, Ms. Rubio thought that we were set for 2. My office was told to appear at 10, so we did that. But I'm at the court's orders, whatever Your Honor says, Judge.
I guess the answer is it depends, Ms. Flores. The court gave verbal instructions at the, well, no, I know that the court gave verbal instructions and Ms. Rubio was definitively one of the persons there, so she knew. But more importantly, Mr. Guzman, is this a contested or agreed to request?
So I think everybody's okay with us appointing a child custody evaluator. I think the point of contention is who pays for it. And so that's really the only thing, Judge.
Ms. Garcia?
Your Honor, if I could clarify just a little bit, at the last setting is when AT&T crashed all of us and we were all in the well. The court did say on the 5th of May too. So I do want to, in fact, I myself only this morning when I checked saw that it was 10 o'clock for the leftover cases from last week. As Mr. Guzman has stated, I think I understood that Ms. Rubio did not have an issue with the study. I don't know anything about her request for costs or anything related to costs, but I can likewise also log in at two of your honor requests. Alternate item I have spoken.
In fairness to Ms. Rubio, the court would like to hear if it is definitively agreed to and whether there is an agreement or a disagreement as to the payment of fees if it is unopposed. So I've already called this case. I'm going to recall it after 2 p.m.
Yes, Judge. Understood.
Thank you all.
Thank you.
I've got nothing further, Your Honor. May I be excused?
Yes, good to see you. Have a great day.
Have a good day, Judge.
Attorney Oscar Vela, page 2, number 4.
Veronica Ann Flores Juan Flores Lavoy, cause number 2021 FLA 1771C3. Court marks Mr. Vela present and participating by video conference. Veronica Flores, are you present?
She's not present, Judge. I'm here for her.
Court finds Ms. Flores not present. Are you Juan Flores Lavoy?
Yes, Your Honor.
Welcome to court. The court marks you present. You're participating by video conference. Mr. Lavoy, do you have a lawyer?
No, I was never served with any documents or anything like that, so I have no clue what this is about.
Will you, the question I usually ask is inapplicable at this time. Mr. Vela.
Yes, Judge. I apologize for Mr. Lavoy. We've been trying to serve him for 2 weeks. This is a motion to modify that has been filed. We were going to come today to ask for a continuance or a new setting because we didn't have Mr. Lavoy served, but he's present. I'm not sure if he's going to be representing himself. We could serve him wherever he would like, and he could get a lawyer or represent himself. I'll be more than happy to confer with him if necessary, Judge.
These are temporary orders. So, Ms. Flores, give us another temporary orders setting, please.
Yes, Your Honor, that'll be June 2nd at 2 p.m.
All right, Mr. Lavoy, Mr. Vela and his client will attempt service again. Once you're served, the only thing the court would suggest, you're welcome to represent yourself. If you decide to hire a lawyer, do so as soon as possible so that person is up to speed, can be ready on June the 2nd, and can represent you well. Do you have any questions for the court, Mr. Lavoy?
Yeah, like where can I get a filing of whatever she filed?
Say that again.
So I can, like, I don't know what she's filed, what she's alleged, what's anything like that. Where can I get documentation for that so I can take it to my attorney?
Don't worry about that because at this point, because you've not been served, because you haven't been served, I can't make a decision one way or the other. So it's the petitioner's responsibility to get you those documents. They're going to do it again or try to do it again soon. Once you receive those, then talk to whoever you would like if that's what you choose to do. And if you hire a lawyer, just make sure that they have adequate time between now and June the 2nd to prepare for your case.
Yes, Your Honor.
I'm sorry.
Can please provide us with an email address?
Mr. Lavoy, what is your email address?
It's JUAN_FLORES@yahoo.com.
Well, just be on the lookout for your email. If the court needs to send you any notices, any information, it's going to go to that email address. I'm sorry, you had another question, Mr. Lavoy.
Oh, yes, I just wanted just to clarify, the next date would be June 2nd at 2 p.m.
Yes.
Okay.
Do you have any other questions?
Yeah, I'm just blindsided by this. I happened to check my mail twice in the same day and found the letter. Um, but for Miss Veronica's attorney, she has my current address.
Yes,
I don't
sir.
understand.
My process server has gone to 5016 Nispero Lane in Laredo, Texas on 3 occasions. But it has been unable to reach anybody. So he's knocked on your door. He'll try again if that's your address.
What time is he? What time is he going there? Just to help the cause,
So let me it's probably a good and fruitful and productive conversation, but it's a conversation that probably shouldn't happen. So just know that it's
Okay.
coming. Mr. Vela will send the process server out again, and then I will come back on June the 2nd. Anything else on this case, Mr. Vela?
No, Judge. Thank you.
I wish all persons well. Have a good day.
Thank you,
Thank you, Your
Judge.
Honor.
We'll see you this afternoon, Judge.
Yes, sir.
Sure. So I'd like to go through the docket, Your Honor. We still have a recall, on page one, number
Let me
one.
call the rest of the cases that have not yet been called.
Yes.
Page 2, case 3, Ruth Garcia versus Gabriel Steve Juarez, cause number 2016 CVW 604C3. Mr. Jordan Miscapello, are you present? Court finds no lawyers present other than Mr. Raul Gonzalez from the AG's office by video conference. Ruth Garcia, Gabriel Juarez, are you present? Court finds no parties are present. There is a request to withdraw. This case is set for dismissal on May the 19th. So notice that this request for withdrawal will be heard on May the 19th together with that dismissal. Anything to add, Mr. Gonzalez?
No, Your Honor, I believe the Office of the Attorney General did file the financial activity report, but other than that, I don't think we have anything to add.
Thank you, Mr. Gonzalez. Page 3, case 8, Cynthia Garcia, Ruben Garcia versus the Department of Family and Protective Services, cause number 2025 FLF 1015C3. Ruben Arce, attorney Ruben Arce, are you present? Court finds counsel not present. Party Cynthia Garcia, Ruben Garcia, or the Department of Family and Protective Services. Any parties present? Court finds no parties are present. Are there any filings in this case?
Oh, Your Honor.
This is now the third setting. Give us a dismissal setting, please.
And how much time, Your Honor?
This 6 weeks.
June 18th at 9 a.m.
So ordered. Leaves one matter. Ms. Flores, is the court correct? That's just one matter pending?
Yes, Your Honor.
That is page 1, case 1. Tanya Elizabeth San Miguel Alberto Pina, cause number 2011 CVG 2217C3. Mr. Perez, Mr. Knotts, and the lawyers were present when the court first called this case, as were both parties, and all persons were in person, save and except for Mr. Gonzalez on behalf of the AG's office, who was present by video conference. The court will call this case at 2 p.m. All right, we'll stand at ease until then. Thank you all.
Be back.
Yeah, we saw him.
Jaime, if you can open the courtroom doors, please. If you're inside the courtroom.
Good afternoon and welcome to Webb County Court of Law 2. This is the family law docket for Tuesday, May 5th, 2026. The time is now 1:35. Court is now in session. Assisting us today are Cecia Rodriguez, Court Administrator. Mr. Cuellar is the interpreter. Ms. Flores is the coordinator. Video conference co-hosts this afternoon include Mr. Córdoba, Ms. Noriega, Ms. Cuellar, Mr. Hernandez, Ms. Lozano, and Ms. Flores. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you are in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. Ms. Flores, I believe there was only one case from this morning's docket remaining.
From this morning's docket, Your Honor, there was 2 cases pending.
Yes. Okay, well, let me call those at 2. Let me start with the 130 docket. Page 1, case 1 of the 130 docket. Rogelio Saucedo versus Nalia Guerra Ernesto Guerra, cause number 2016 CVG 1382C3. Court marks Ms. Saldana present in person. Good afternoon. Mr. Tames, are you present? Court marks Mr. Tames not present. Are you Naila Guerra? Welcome to court, Ms. Guerra. Court marks you present in person. Are you Rogelio Saucedo Jr.? Welcome to court, Mr. Saucedo. The court marks you present in person. Ernesto Guerra, are you present? Court finds Mr. Guerra not present. Is somebody here on behalf of the Attorney General's office? I'm going to mark Mr. Raul Gonzalez's device logged in. He's present by video conference, or at least his devices. Mr. Saucedo, have you had an opportunity to talk to your lawyer?
He said he was gonna be here today, but that's about it.
All right, Ms. Aldana, announcement?
Well, yes, Your Honor, we are here on a petitioner's verified motion to show cause, motion for contempt, et cetera, for discovery. Just to let the court know, we have submitted to Mr. Tames's office supplemental answers to interrogatories that have been signed in front of a notary, as well as supplemental requests for production. We do just have a couple of questions on 2 of the responses. We wanted to get guidance from the court, if we may.
So this is Mr. Tames's motion?
Correct.
And you think that you've complied with the requirements, but I still have 2 questions?
Correct.
Well, I guess let me put this case on hold. And has Mr. Tames called the office or emailed or?
Yes, Your Honor, he did call that he was on his way. Your Honor.
I guess as with all things, I guess let me ask this, Ms. Aldana, have you had an opportunity to confer with Mr. Tames on those 2 things?
I have not.
So let that be the first thing that happens. And then whatever your decisions are, I will hear, and anything you disagree with, I will consider after.
Yes, Your Honor. Thank you.
All right, good luck.
Thank you.
Stand by. Ms. Flores, we have 2 cases from 10, 1 from 1:30, and the remaining from 2 p.m. Are there any cases that are ready?
No, Your Honor.
All right, court will stand at ease. Well, no, before we do, let me ask, is there any lawyer who's present, logged in online, that has any announcements, pure announcements for the 2 p.m. docket? Ms. Aldana?
Yes, Your Honor. I actually have one with Julia Rubio. I don't know if she's present online, but we are in agreement.
Page 1, number 1, Your Honor.
This is Fernando Vasquez versus Yvette Josephine Vasquez, cause number 2003 CVG 1233C3. Court marks Ms. Alenia present in person. Attorney Julia Rubio or parties Fernando Vasquez, Yvette Josephine Vasquez. Are any parties present? Court finds no other persons are present. Ms. Alenia, go ahead.
Yes, Your Honor, I've been conferring with Ms. Julia Rubio and our office and her office. We're in the process of trying to get more information from OPM. So we are moving the case along towards finding an amicable resolution ideally. So there's nothing to pre-try.
Interesting. I think you might be right. Let me hear from the clerk's office. Has anything been filed for the court to consider at this pretrial hearing?
No, Your Honor.
Court finds that there is nothing to pre-trial. You're absolutely right. So this case goes on to final hearing and disposition on June the 18th at 9 a.m.
Yes, Your Honor. Thank you.
Thank you, Ms. Alenia. Any other cases with announcements, Ms. Alenia?
No, Your Honor.
Yes, the lawyers present by video conference. And that's only Mrs. Cotto. Mrs. Cotto, any announcements on the 2 p.m. docket? All right. Then the court will now stand at ease.
All right. Court is adjourned.
Welcome to Webb County Court at Law 2. This is the Family Law Docket for Tuesday, May the 5th, 2026. The time is now 2:10. Court is once more in session. The court had previously given some admonishments. Those stand. Ms. Flores, would you call the next case, please?
Yes, Your Honor. First case in person with attorney, Mr. Tamez and Ms. Aldana. That will be page 1, number 1, the 130 docket, Your Honor.
Rogelio Saucedo Jr. versus Naila Guerra, Ernesto Guerra, cause number 2016 CVG 1382C3. Court marks Mr. Tamez present in person, Ms. Melissa Saldana present in person, Rogelio Saucedo present in person, Naila Guerra present in person. Once more, Ernesto Guerra, are you present? Court finds Mr. Guerra not present. Counsel, what is the announcement?
Your Honor, we've conferred briefly on the matters before the court today. Counsel for Ms. Guerra has represented to me that they sent some documents that were responsive, a part of today's motion to show cause. We didn't receive them. At 12:40 this afternoon, I received some supplemental or amended responses. I had to rush back to the office to pick those up, and I have not had a chance to review those carefully. But for purposes of today, Judge, we're going to request a reset for a month so I can review that. And counsel has asked if we can attend mediation. I think we're okay to go to mediation. But there are a couple of other things that I want to make sure that are put on the record. Judge, Mr. Guerra, under agreed order, was supposed to supplement responses by Friday, last Friday. I didn't receive those. Counsel is going to look into providing that discovery. And I also want to point out the rule of procedure number 1. The objective of these rules, Judge, is to make sure that we, to the end of justice, make sure that we give these rules ample opportunity to be enforced to make sure the litigants can litigate with the least expense possible and to not take up the court's time. We're amenable to resolve this, but I needed to put on the record that we should have to file a motion to show cause. We should have to file another motion to compel. Those are things that the rules allow us to do, but that's not something that is efficient for our clients or for the court in the administration of justice. So we're going to ask the court for a reset, ask the court to admonish the parties that they need to respond to discovery pursuant to the rules. And we're going to look into trying to schedule a mediation. We do have a appraiser that has already scheduled time to go appraise the property. And so in case we can't resolve that this case, we'll obviously seek a division of the value of that property pursuant to the prior orders or the prior report that the court got from the Master and Chancery.
Ms. Alani.
Yes, Your Honor, thank you. So that is correct. We are in agreement with a reset and we are in agreement with a mediation. I think that the parties are in a position where I think they're more open to negotiating and we're ideally working something out. As far as Mr. Guerra's discovery, we will provide the interrogatories. I'll review that and see what's missing, what from there is missing, and send that to Mr. Gomez. As far as Mr. Saucedo having to file a motion to show cause, that was unnecessary, and in fact, it was harassing and abusive. It was just an excessive amount that was being requested. When that was the first time that we actually conferred as far as what exactly was pending, because we had submitted the responses the first time and we supplemented responses after that. And it wasn't until it was in writing with this motion to show cause about specifically what was missing that we were able to then provide that as well. So we have not been trying to waste the court's time. In fact, it's the opposite. We've been trying to work out this case with Mr. Saucedo. However, this is where we're at.
Mr. Tamez, Ms. Saldana, I know you've agreed to mediation. Have you agreed to a mediator?
I think so.
Well, we had previously, it was, I think Judge Hale, Your Honor, and I'm okay to go back with use Judge Hale. I think the only thing there is I want to make sure that we have the documented information that we have originally planned to get back in December. Before we can try to make informed decisions at mediation. That's what this whole exercise has been the last 5 minutes.
So then, Mr. Tames, is your request here to reschedule your motions or just to go straight into final on June the 18th?
I asked to reset. I need to verify. Yeah, I'd like to trust, but I need to verify. And I think I owe that to my client, my duty to my client, to make sure that we have the responsive documents and those answers for them. So I don't look, we all have technical issues. And Ms. Aldana told me that they had emailed documents responsive. We didn't receive them. So there might have been a mistake. I think she has a USB. I said, put it on a drive. I'll go pick it up at your office. So, but that's why I would like to reset it. I don't want to take up the court's time today, trying to do all this today.
All right.
And just as long as the Ms. Guerra is still under the precept that we had an issue and that she's ordered to make an appearance at the reset.
Any objection to that,
No,
Ms.
Chair.
Aldana?
No objection.
All right, I'm gonna schedule these matters for Ms. Flores. Give us either June 2nd or 4th, whichever has less cases.
June 2nd, Your Honor.
June 2nd at 2 p.m. The court will hear this, and then you'll come back to your final hearing on June the 18th at 9. Mr. Salcedo, do you have any questions for the court?
No.
Ms. Guerra, do you have any questions?
No.
All right, keep in contact with your lawyers. I think the choice or the agreement of Judge Hale is probably a good thing for this case because you're asking me to make a decision based on the facts and circumstances and I guess the decree in this case, and that's something that Judge Hale probably was asked to do repeatedly over many years. So he can give you some thoughts as to what he could have done had he heard this case, and you'll know more or less what could happen at your final hearing. I wish all persons well at mediation. Good luck to everyone.
Thank you, Your Honor. Have a good day, sir.
Likewise. Yes, have a good day.
Next case, Your Honor, Attorney Adriana Benavides Maddox, page 4, number 10.
Monica White, Brian White, cause number 2025 FLA 1592C3. Court marks Ms. Maddox present in person. Good afternoon.
Good afternoon, Judge.
Mrs. Cotto, are you present? Court has not admitted all persons. Court is admitting all. Ms. Escoto was logged in when I first stepped on the bench, 15 till 2 or 20 till 2. Court finds that Mrs. Escoto is not present. Monica White, Brian White, are you present? Court finds no parties present. Ms. Maddox, go ahead.
Yes, Judge. In this matter, we received a final settlement offer from Mrs. Soto's office late last week, and I reviewed it with my client early this morning. We're working on a counteroffer. I have communicated with Mrs. Soto regarding the same, and we have agreed to attend mediation with Judge Hale. And so we would like the opportunity to do that before we have a trial before the court. And we're hopeful that we can either settle amongst ourselves or at mediation with Judge Hale.
The court is signing off on that order. It is agreed to. I don't know his schedule or yours or Mrs. Coto's. How much time out would you like for that final setting to be
I
set?
think sometime in mid to late June.
Give
because
us,
Mrs. Cotto, I believe, has a vacation letter on file.
Do you know the dates of that letter? It's not part of the court's files yet. Yes, July 23rd through 28th.
Is there a June date at all?
Oh, no. I'm saying those are Mrs. Cotto's vacation day
Oh.
letters. Yes, Ms. Flores, give us a setting in June. It doesn't conflict with Mrs. Cotto's letter.
June 18 at 9.
All right, so the court is going to order then that mediation take place on or before June 15th, 2026. The court has written in Senior Judge O. Hale Jr. as the court's appointed and agreed to mediator in this case. Mediation is to take place on or before June 15th. This case will be heard and the court is tendering that original signed copy to the coordinator, and then we'll come back for a final hearing on June the 18th at 9. Anything else on this case, Ms. Maddox?
That's all, Judge.
Any other cases for Ms. Maddox?
No, yeah.
No, that is all, Your Honor.
Have a
Thank
great
you.
day.
You
Good to see you.
Next case, Attorney Julia Rubio. Page 1, number 1.
I'm sorry, did the court call my case with Miss Maddox?
Yes, the court heard, I'm going to recall it now, 2025 FLA 159C3. Court called this case at 2:18. Court heard from Ms. Maddox that there was an agreed to mediation. The agreement was Judge Hale, the court appointed Judge Hale, signed that order, and then set this case for final hearing June 18th at 9. Because I set it on that date, the court set the mediation date on or before June 17th.
That's fine, Judge. I'm gonna send Miss Maddox some discovery, so that'll give her enough time to respond.
Good luck to all.
I have the dates. Thank you, Judge. May I be excused? That's all I had.
Have a great day. Yes.
You too, Judge.
I'm sorry, you said page 1, case 1?
Yes, Your Honor.
Fernando Vasquez versus Yvette Josephine Vasquez, cause number 2003, CVG 1233C3. Court marks Ms. Rubio present in person, Ms. Alania also present in person. Fernando Vasquez, Yvette Josephine Vasquez. Any parties present? Court finds no parties present. Counsel, what is the announcement?
The same announcement from earlier, that we are working to get some more information from OPM and just hoping to resolve this as soon as possible.
We can stay on for the final hearing, Judge.
All right, good luck to everyone. I'll call this case on June the 18th at 9.
Next case, Ms. Aldaña, Your Honor, that'll be page 1, well, page 2, number 4.
Alma Alicia Salas Vasquez versus Anthony Bouvier, cause number 2018 FLI 1884C3. Court marks Ms. Aldaña present in person. Marcel Knotson, are you present? Court finds Mr. Knotson not present. Raul Gonzalez is present by video conference. Speak into the microphone, Mr. Bouvier, and tell the court, are you Anthony Bouvier?
Yes, Judge.
Welcome to court, Mr. Bouvier. The court marks you present in person. The person to your left is your lawyer. Court marks Mr. Knotson present in person. Alma Alicia Salas Vasquez, are you present? Court finds Ms. Vasquez not present in person, not present by video conference. Ms. Aldaña, Mr. Knotson, what is the announcement?
Your Honor, we just have a motion to interview the child in chambers. That's it. So I don't think it'll take more than like 3-4 minutes to argue it.
Very simple, yeah, very short argument.
Who disagrees?
My client, Your Honor, the child is under 11 years old and autistic. And for those reasons, she's asking that he not be interviewed. And that's the argument.
2 questions. First question, can you flesh out the argument as to what exactly I mean, I understand, but is it, I don't want to give you thoughts or put words in your mouth, but is the court not capable of this, or what is the objection?
She has concerns about his ability or inability to communicate. And is concerned that that may be misinterpreted as something that's not actually beneficial to my client, to the child.
So the objection is that the court would misinterpret a child's inability to communicate, and that would prejudice your client?
That the child would not be able to communicate.
Is the child audible?
Yes.
He is audible.
So then I guess the only other question response, Mr. Natson.
Yes, I think it's very simple. I do have confidence that the court will be able to discern immediately the child's intelligence, his ability to communicate. And if there are any such issues in communicating with the court, you will simply tell the parties, look, I don't think he's capable of communicating that, so it's not going to affect me one way or the other. I'm going to hear the evidence on this case and we'll make a decision on that. Or if it is helpful, the court can tell us why it was helpful and what your thoughts are, and I'm sure the case will get resolved quickly. So there's no harm in, and when's his birthday?
September 30.
So he's going to be 12 in September, Judge, just a few months away. May, June, July, 5 months, less than 5 months away, Judge. He's over 11 years and 7 months old. And I've talked to him. He seems fairly intelligent. I don't know if Ms. Saldana has. I don't have any concern that he's, an introvert or anything of that nature. He's, I think, going to be able to communicate fine and what he wants, why he wants it. And the court will be able to ask whatever questions in your wisdom that you think are appropriate.
Well, we don't have any access to the child. And in fact, the agreement that we had was to address the visits with mom up until this past weekend. So I would ask that we confer about additional visits.
Yeah, we can do that.
Okay.
So just on the interview of the child, that's all I have, Judge. I think it'd be helpful for the court. And you can schedule it at your convenience. We did not bring the child here today. It was just the hearing. If it's granted, you tell us when, and then we would have him there. What time does he get out of school?
2:45.
2:45.
So, Ms. Saldana, Mr. Natson, in this situation, custody ostensibly is at issue. I think the court, so what the court always does in these situations, if custody is at issue, the court does interview. The question before the court is whether it would be productive or not for the court to interview a child if it is at all possible that the child has limited communication capabilities. And obviously, conservatorship being the main issue, the things that a judicial officer sitting in family law cases can learn about a case is not only their preference, but for example, whether there has been influence, how the person is doing, how they communicate. It's not solely for the main issue, but there are a lot of things that are gleaned, even if this child is somehow limited in his ability to communicate. Perhaps the court will come away with that understanding and perhaps that finding. So there are many benefits to this interview. I haven't been provided sufficient information to deny the request or to think that this child would somehow be harmed. There is no argument, evidence, or proof that that would even happen. So, the court is going to be consistent across all cases. When requested, it's granted on the day of the final hearing. You're set for final hearing on June the 18th at 9. The interview will take place at 11 a.m. Any thoughts, comments, questions, or objections, Ms. Aldana?
Did I understand correctly? The hearing, the final hearing is at 9 and the motion to confer is at 11?
Yes.
Okay.
So we'll start the hearing, or you'll be taking announcements at 9 and then maybe interview the child, and then from there.
My best guess is that by the time the court clears announcements and prove-ups, it'll be 11. I'll interview and you go straight into your contested matter if it is in fact contested. You're set for final pretrial June the 16th at 2, final hearing June the 18th. Same question to you, Mr. Knotson. Thoughts, comments, questions, or objections?
No, I think you summarized it beautifully, Judge.
Mr. Bouvier, do you have any questions for the court?
No, Judge.
Mr. Bouvier, keep in contact with your lawyer. Ms. Salas Vasquez will do the same thing. I wish both of you well. Good luck.
Thank you, Judge.
May I be excused then?
Have a great day.
Thank you.
Next case, Your Honor, is Attorney Ruben Arce, page 3, number 8.
Ashley Anali Martinez versus James Castaneda, cause number 2024 FLA 1863C3. Court marks Mr. Arce present in person. I believe Mr. Chu was present. Mr. Julio Garcia, are you present? Court marks Mr. Garcia not present. Ashley Martinez, James Castaneda, are you present? Court finds the parties not present. Mr. Arce, what is the announcement?
Good afternoon, Judge. This was for entry of judgment, Your Honor. I know that myself and Mr. Chu are working to finalize this matter. I believe that he submitted it for signature, Judge. Good afternoon, Judge.
Good afternoon, Mr. Chu. It looks like there's an order in suit to modify signed by both lawyers. This is the agreement, Mr. Arce?
Yes, Judge, that's the agreement.
Mr. Chu?
Yes, Judge.
The court has received, reviewed, and considered the order in suit to modify parent-child relationship. It is signed by both counsel. The court has approved it. The court is tendering the original signed copy to the coordinator. And that concludes this case. Congratulations to each of you and your clients.
Thank you, Judge. Thanks, sir.
Next case for Mr. Arce, page 4, number 11.
Jessica Nicole Hernandez versus Jose Angel Rodriguez, cause number 2025 FLA 1619C3. Court marks Mr. Arce present in person. Mr. Juan Garcia is present by video conference. Good afternoon to both.
Good afternoon, Your Honor.
Jessica Hernandez, Jose Rodriguez III. Any parties present?
Your Honor, Mr. Rodriguez was here, but I believe he was in the hallway.
Jose Rodriguez, if you're present, please step forward. Step in front of the microphones and tell the court, are you Jessica Nicole Hernandez?
Yes, I am.
Welcome to court, Ms. Hernandez. The court marks you present in person. As you can see from the screen, your lawyer is present by video conference. Are you Jose Angel Rodriguez III?
Yes, sir.
Welcome to court, Mr. Rodriguez. The court marks you present in person. The person to your left is your lawyer. Mr. Arce, Mr. Garcia, what is the announcement?
Your Honor, I believe that we're here for a pretrial judge and the signing of the temporary orders, Your Honor. I've been conferring with counsel, Judge. I don't believe that there's anything at this point to pre-try. There was some issues that my client brought up to me, Judge, but I'll go ahead and confer with Mr. Garcia in reference to that.
Anything for the court to consider at this pretrial hearing, Mr. Garcia?
No, Your Honor, just the same thing, just for the, I think for the signing of the orders, Your Honor.
Yes, the clerk's office.
They were filed, Your Honor, February 23rd. However, I believe we need to refile the proposed order with Mr. Arce's signature.
Do you have any objection to the court signing off on those?
I do not, Judge.
So I don't need anybody's signature, not even one lawyer. Can you just print that out? Let me just sign them right now.
Yes, printing, Your Honor.
Thank you. Was reviewing the court's notes, Mr. Garcia and Mr. Arce. It looks like there may not be a contested issue as to the paternity of the expected child, but and I don't know when the due date is, but
That's the
is,
one thing that we're gonna discuss with counsel, Judge, is that my understanding that the due date is mid-June, Judge. So of course, we're gonna see if we could get a paternity test done just to err on the side of caution, Judge, and we can include that language in there, exclude my client as the father of the child. And we want to do that prior to that July date, Judge.
do you believe, well, I guess she's your client, Mr. Garcia. Do you think the expected delivery date is sufficient time between then and July the 9th for a paternity testing?
It should be, I think the due date, well, it'll have to be a date after, I think June the 19th, Your Honor. I think her expected due date is that June 19th.
So we're set for final hearing on July the 9th. Is that sufficient time, or do you think we should give this case some more time?
Probably some more time, Your Honor.
I would just ask maybe 2 weeks, Judge, just to be on the safe side. I'm not sure, depending on recovery, Judge, and all those things.
I presume that would be prudent. Ms. Flores, give us another setting in July, please, after July the 9th.
July the 30th at 2 p.m.
Right, the court has signed off on the agreed to temporary orders. The court is tendering the original signed copy to the coordinator. And then we will come back for a final hearing on July the 30th at 2. Ms. Hernandez, do you have any questions for the court?
I guess just what on the orders of, since it was a while ago, I don't know what was placed on them.
I think the best thing I can tell you is just remain in contact with your lawyer so that he can answer all your legal questions and advise you accordingly. But do you have any questions for me?
No, Your Honor.
Mr. Rodriguez, do you have any questions?
Not today, sir.
I wish you both very well, and Ms. Hernandez, I wish you a safe delivery.
Thank you.
Good luck to all.
And it just to inform the court, I believe that they had been working to have visitation done. Sometimes it's not by the order, Judge, because I know that they didn't have it in place, but they've been working on the visitation.
I think that's a good thing. Good luck to everyone.
Thank you.
Thank you, Your Honor. May I be excused?
Have a great day.
Thank you, Judge, you too.
If I could just bring something up to the court's attention, Judge. It's a cause number. It's a cause number, Judge, that I believe was set possibly in the morning, Your Honor. But this was the day that the internet service went out.
That was on page 3, number 8, Your Honor. AM docket.
It was 2025 FLF 001015C3.
So on the 10 o'clock docket, page 3, case 8, cause number 2025 FLF 1015C3, court called that case at 12:04. Mr. Arce wasn't present, no persons were present. This case is now set for dismissal on June the 18th at 9.
Yes, Judge, I inadvertently, Judge, and I maybe heard that it was set for 2 that day that the internet went out, Judge.
Oh, I see.
So I had set it on my calendar for 2 o'clock.
We'll just set it for final hearing then on the same day.
I appreciate it, Judge.
Yes, sir. Final hearing, June the 18th at 9 a.m.
And that's a matter, Judge, where it's a stemming from a CPS termination.
Well, let me ask you this, Mr. Arce. So now I'm hesitating because I don't think there's any service on respondent.
Well, the respondent is CPS, Judge. I've been talking to them already. They just need to return the documents, and basically it's just the fact that they're not going to object.
Do you think they'll waive service or?
Basically, I believe it's a waiver of service that we gave them, Judge.
Understood. Okay, well
So
taken.
So they've got, my clients have possession of the child and have had possession for years, Judge. And it's just CPS waiting on the birth certificate to be corrected. I believe that they had inadvertently sent the wrong name, Judge. That's the only thing that's kind of holding it up. We're waiting for the state to send a corrected birth certificate and submit all documents.
Well taken. We'll go forward with the final hearing on June the 18th.
Yeah, Judge, I know it's a lot to ask her, but I don't know if that day is a date that has like a heavy docket, Your Honor. I think they wanted to bring in family to celebrate that day.
We're scheduled at 9, which tells me that it may be heavy, and just want to space it out. How many cases do we have set on the 18th?
We have about 15 cases right now, Your Honor.
It's medium light.
Okay.
Well,
And-
I say that.
And that's a family law docket only, Judge.
Yes, only family law.
I think they just wanted to celebrate the day and bring family.
I welcome them.
Thank you, Your
All
Honor.
right.
Judge, that's all I have. Anything?
Good to see you.
Thank you, Judge.
Have a
Thank
great
you for
day.
your assistance.
Next is Your Honor, Attorney Oscar Vela, page 3, number 6.
Noemi Mireles versus Luis Castillo, cause number 2023 FLC 1507C3. Are you Noemi Mireles?
Yes, I am, Judge.
Welcome to court, Ms. Mireles. The court marks you present. You're participating by video conference. Are you speaking to the microphone and tell the court, are you Luis Castillo?
Yes, sir.
Welcome to court, Mr. Castillo. The court marks you present in person, Mr. Castillo. Do you have a lawyer? Are you going forward without a lawyer?
Yes, sir. Yes.
Court marks you self-represented, and court marks Mr. Oscar Vela present in person, and Mr. Raul Gonzalez is present by video conference. He's here on behalf of the AG's office. Mr. Vela, go ahead.
Judge, we had previously been here, and the court gave us today's setting because the attorney generals had requested that Mr. Castillo provide some financial information. He gave me a copy of the 2025 tax return and a 1099 for 2025. And so the attorney generals had asked for him to produce income tax for 2 years and his 1099 for 2 years and his paycheck stubs for the last 6 months and his policies for insurance. And so we're here on that motion for the production of documents. I think Mr. Castillo had told us last time we were here that he had not filed his 2024 tax return, 2025. And so I'm not sure if Mr. Castillo brought additional information.
No, I did it, brought some check stubs for my new job. That's all I got right now.
You brought what now?
Check stubs.
Check stubs. How many check stubs did you bring today?
For 5.
5. And you said this was a new
Job.
job? How long have you been there?
It's the last board we had.
This is a very, very new job.
Yeah.
All right. Anything on behalf of the AG's office, Mr. Gonzalez?
Yes, Your Honor. I would just ask for, I would just ask that that evidence to be submitted to the OAG. I do have the 1099 NEC from this year, the 2025, and I do have the 2024 the 1040 form, the tax return, but pretty much anything new. There is a very, very large disparity between the salaries in between 2024 and 2025. So anything new, the pay stubs, we would ask for those pay stubs, and anything new that he could offer us in order to get those wages and make an accurate estimate would be the best.
Well, we were last here on March 31st, and it sounds like, Mr. Vela, you just recently received these documents?
No, Mr. Castillo and I met outside of the courtroom after the hearing, and then he emailed me the 2024 and the tax return and the 1099 for 2025 immediately within the week. So he did share those two things with me. We're just missing information for 2025 tax return, the 1099 for 2024, and his paycheck stubs, which now he says he brought to the courtroom for his most recent job.
Mr. Castillo, have you had an opportunity to file your 2025 income tax return?
Not yet.
Have you requested an extension?
No.
Are you intending to file? Do you know when you would be filing?
No, like, cause they told me that it was gonna be like 250 and I didn't have the money at the time, so I just said to let me save up for that and I was gonna file it.
And what about your 2024 1099? Do you have that information?
Which one?
Your 1099 for 2024.
24? I don't have one. It's what is it?
This is the 2025 1099. 2024.
I would need to look for it. Like, I don't think I have that one.
Mr. Gonzalez, what is the best way that Mr. Castillo can provide this information to the Attorney General's office?
Sir, if you could email us, I can provide him with an email address.
What is that email address?
Yes, it can be the CSD-LEGAL-305 at OAG period TEXAS period GOV.
Did you get that, Mr. Castillo?
I need to get it something. I don't have pen.
Please provide Mr. Castillo paper and a writing instrument. And a surface that isn't the lower bench to write on. One more time, Mr. Gonzalez, so that Mr. Castillo can write it down. Go ahead.
That's right. It's CSD-LEGAL-305 at OAG period TEXAS period GOV.
Did you get that email address, Mr. Castillo? All right. So exchange this information, and then we'll come back to court. Well, no, this is your motion. This is the AG's motion.
This is my motion, Judge.
Are you moving on it?
No, as long as he provides the check stubs that he has. You already gave us a final hearing for June. I've been conferring with Mr. Castillo. We're trying to reach a final resolution. But I was hoping he would provide the information so the AG's office can help us compute a proper child support calculation.
And we're happy to do so, Your Honor, just as long as we have the proper evidence.
What I could do, Judge, is just I'll abate my motion. I'll ask Mr. Castillo to send me or give me his paycheck stubs so I could take them with me, and then we'll see if we need to take additional steps.
All right. I'll call this case for final hearing on June the 4th at 2 p.m. Ms. Mireles, Mr. Castillo, I hope to resolve this finally on that date, pending the transmission of those financial documents. Ms. Mireles, do you have any questions for the court?
No, Judge.
Do you have any questions, Mr. Castillo?
No, sir.
Anything else on this case, Mr. Gonzalez?
No, Your Honor. Thank you.
Mr. Vela?
Judge, just want to advise the court and put it on the record that Mr. Castillo has given me a paycheck stub from April 10th, April 17th, April the 3rd, May the 1st, and April the 24th.
So noted. Ms. Flores?
Would this be an in-person hearing, Your Honor?
If it's contested, I would prefer that in this situation, but I don't know that it will be. Unless you all deem otherwise, fine, it's okay to be hybrid. All
Thank
right,
you, Judge.
we'll see you on June the 4th. Good luck to everyone.
Thank you.
Next case, Your Honor, with Attorney Oscar Vela, page 5, number 14.
Derek Andrew Hale versus Sylvia Alicia Hale, cause number 2026 FLA 619C3. Court marks Mr. Vela present in person, Mr. Chu present in person. Speaking,
Judge,
good
Nick Chu
afternoon.
present for Miss Sylvia Alicia Hale.
Speaking to the microphone and tell the court, are you Sylvia Alicia Hale?
Yes, Judge.
Welcome to court. The court marks you present in person. The person to your right is your lawyer. Are you Derek Andrew Hale?
Yes, Judge.
Welcome to court, Mr. Hale. Court marks you present in person. The person to your left is your lawyer. This is temporary orders and docket control conference. Counsel, what is the announcement?
Judge, we don't have an agreement. We'll need to have a hearing for the temporary orders, Judge. That'll determine JMC with custody and visitation and the house and the dog and child support, Judge.
Mr. Vela?
That's correct, Judge.
Just want to make sure that I know it was almost stream of conscious, but just so the 4 contested issues are the conservatorship, exclusive use of the home, possession of a dog, and child support.
Yeah, and visitation and access to children, Judge. They are under 3.
How many children before the court?
2, Your Honor.
Ages?
2 and 6 months old.
Genders?
First one is a female, the second one is.
Baby is a boy.
Well, this will be the first contested matter that the court hears today, so I'm going to ask and instruct you, Mr. Vela and Mr. Chu, confer with each other and see if you can get it down to 3 out of 5, 2 out of 5. If not, I'll hear 5 out of
We
5.
had already tried before.
Good
coming
luck.
Before you, Judge.
All right.
Thank you, Judge.
Thank you.
Next case, Your Honor, from the AM docket. Attorney Julia Rubio, page 4, number 9.
Juan Antonio Lesa versus Linda Sanchez, cause number 2025 FLI 281C3. Mr. Guzman, are you present?
Here, Judge.
Welcome to court once more. Mr. Guzman, the court marks you present by video conference. Court now marks Ms. Rubio present in person. Are you Juan Antonio Lesa?
Yes, sir.
Welcome to court once more. The court marks you present by video conference. Linda Sanchez, are you present? Court marks Ms. Sanchez not present. Court marks Raul Gonzalez present by video conference on behalf of the Attorney General's office. Are you Linda Sanchez?
Yes, sorry, I'm
Welcome
trying
to court. The court marks you present by video conference. All persons are present by video conference except Ms. Rubio is present in person. Counsel, what is the announcement?
Judge, Mr. Guzman has a motion on file for the appointment of a child custody evaluator. We don't have necessarily an objection to the appointment of one, but we do have an objection to my client being ordered to pay for it.
Well, so I guess, and the court marks Ms. Leticia
Good afternoon,
Garcia also
Judge.
present by video conference. Well, I guess payment isn't an issue unless it's first proven. Mr. Guzman, go ahead and argue the request for an evaluation.
Yes, Judge. We feel that we need one because in this case, the primary conservatorship, we requested a jury and we're headed towards a jury trial at some point, Judge. I don't know when it's scheduled for at this point, but it would be in the child's best interest or in the children's best interest that a child custody evaluator be appointed. And because it's in the children's best interest, both parties, like in most cases, both parties should bear the burden of having to pay for that on a 50-50 basis. So we're not requesting that Ms. Sanchez pay the entire amount, but we are requesting that she pay half of the amount, which is what we normally do in these cases.
Judge, may I be heard?
Yes, just give me 1 second. I'm just making some notations on the motion itself. Yes, before you respond, and I'll give you ample opportunity to do so, Ms. Rubio. Mr. Guzman, Ms. Rubio, how many children before the court?
2,
Ages?
9 and 19 months, about 1.5 years.
Genders?
Both are boys.
All true and correct, Mr. Guzman?
Yes, Judge.
All right, so 2 boys.
He's 16 months old.
Right, I heard,
I added 1 instead of subtracted 1, Ms. Sanchez, sorry.
I did hear 1.5 years, which is correct. I guess the issues. I just for purposes of full disclosure, I just need Mr. Lessa and Ms. Sanchez to be fully aware. One of my colleagues admonished me that I should do this because everybody needs to be fully aware of the legal situation before they proceed. And you're fully able to contemplate the best interest standards and what in your professional judgments you should do. But in this situation, ostensibly, Mr. Guzman and Ms. Rubio, you're asking a jury to make a determination as to conservatorship.
That's Mr. Guzman's request, Judge. We'd much rather have a bench trial.
Mr. Guzman?
Yes, Judge, we're asking for a jury trial.
So knowing that after the jury trial, this court makes a determination as to possession and access. Is that correct?
Yes, Judge.
Okay.
Yes.
I just want to make sure we're on the same page. Mr. Lessa, unmute your device. I just need to fully know that you understand the request, and I'm not dissuading you. I just want to make sure that we're all on the same page prior to setting these dates, prior to asking for a panel of 60 some odd persons to come in and serve and picking 12. Mr. Lessa, you understand that by requesting a jury, they will decide conservatorship, and then this court, this judge, will determine the possession, access, and visitation. Do you understand this, Mr. Lessa?
Yes, sir, I understand.
Ms. Sanchez, unmute your device. Same question to you. You understand that the jurors in this case will determine conservatorship, that's the rights, but then this judge, this court will determine possession, visitation, and access. You understand this, Ms. Sanchez?
Yes.
All right, anything to add, Ms. Garcia?
Nothing, Your Honor.
Ms. Rubio, you have a floor.
Yes, Judge. At issue ultimately, whether we go forward with the jury trial or whether the issue of conservatorship is put before this court to decide will be the best interest of the children. This case has been on file for almost a year. Mr. Lessa's counter petition, it was originally a case brought by the Office of the Attorney General, was filed July 1st, I want to say. We have an issue on reserve to ask for back pay. Since then, we finally entered temporary orders. I believe in February or March of this year. Ms. Sanchez has still yet to receive a single payment of child support. It was ordered at, I think, $2,000, which is below the statutory percentage, because Mr. Lessa earns, I believe, if not double, more than double what Ms. Sanchez earns. So if we're really looking at the best interest of the children who already have a court-appointed representative who's been on the case for the better part of 6 months, we wouldn't be looking to deplete their mother's disposable income further, especially when she's been given zero support from their father in the way of child support. What court-appointed representatives help the court to do, or a jury to do, is to determine the best interests of the children. And given their ages, I'm not sure that exposing them to a second professional will be in their best interest, or that it's necessary, because we have Ms. Leti Garcia on the case and she's more than capable of providing you with enough background information and a recommendation, or a jury with that information, so that they can make an appropriate determination, Judge.
Mr. Guzman, I'm just gonna flat out read between the lines and summarize that. Ms. Rubio says that your client is putting financial pressure by first not providing child support, and now going out and having her pay half of this request for a professional evaluator when Ms. Garcia can do the same work. What say you?
Well, Judge, first of all, Ms. Garcia, without due respect, she's not a licensed professional counselor, Judge. I know that she does have a lot of experience in family cases with dealing with young children, but she's not a licensed professional counselor. Ms. Sanchez suffered, I believe, a stroke, if I'm not mistaken. And so there's a question as to whether or not she can physically and or mentally take care of both children. And I believe, she's also working at the same time. And so there's all these other issues that need to be heard by somebody that's qualified to look at whether or not these kids are being well taken care of when they're with Ms. Sanchez. And so there's somebody else needs to look at these things, Judge.
It seems more appropriate than, Judge, for perhaps an MD doctor to be subpoenaed as a witness to opine on Ms. Sanchez's physical and mental state. I don't know that a licensed professional counselor will be able to provide this court or any jury with an opinion on her ability to care for her children, given that that person is not a doctor.
Right, but that's something that a licensed professional counselor can look at, Judge, and see what the interaction is between kids. And so that is important. And also, Judge, from my recollection, there were amounts that were being deducted from Mr. Lesa's paychecks in form of child support. And so we did have a hearing on temporary orders, and we have those orders in place, and that's what the board, so that it can get us to a final hearing or trial. And so to say that he's not paying child support, that's disingenuous, because we do have temporary orders, and if that was, agreed to temporarily, then that's what the agreement was.
I met with my client last week, Judge, and as of, I think, Monday of last week, she had not received a single payment. I'm sure she's
Well,
happy
I
to.
think this matter can be, so somebody here is not being truthful. We can just ask the Attorney General's office. Mr. Gonzalez, you're here on behalf of that office. There is allegations on one side and the other of payment and non-payment. What does the financial information activity report show on this case?
Yes, sir. Between February 2026 and the beginning of May 2026, there has only been one payment of $1,194.93, which occurred last month. So it was on April 28th, 2026. And that money should have gone straight to the child support.
Unless there's information to the contrary, the court, I believe, can presume that that is in fact true. What amount, if any, then could be found in arrears, if any?
If we're going to go off of the last day of the last month, Your Honor, for child support, the arrears balance currently is $4,815.07. For medical support arrears is $1,101.84. And for dental support is $157.31, bringing a total of the arrears balance as of last month of $6,074.22. And
All right, so I'm not gonna make a finding, but I guess I can take that information and just make a notation that there is currently alleged non-payment of child support leading credence to Ms. Rubio's position. 1, 2, question, Ms. Garcia. Ms. Garcia, are you
Yes,
able
Judge.
to visit the parties at their residences?
Yes, Judge, I can do that.
All right. So look, folks, given that there has been a non-payment of child support leading, it's alleged, it's not proven, I'm not making that finding, but there isn't any information to the contrary. And Mr. Gonzalez, I'm pretty sure, doesn't care one way or the other. He's just reciting information as it exists in his computer system, leading credence to the preposition that perhaps this request is made to put financial pressure on Ms. Sanchez. The court then reviews the motion as written. The court in the motion is requesting for the court to appoint a qualified evaluator pursuant to the Family Code, Chapter 107. But the specific request is that there is a need alleged, and I'll presume it's true for purposes of this hearing. There is a need for visits to the residence of the parties. The court finds that that request can be satisfied by Ms. Garcia. For that reason, the request is denied, subject to review if asked. All right, since we're set for a jury trial, let me ask you both this, Mr. Guzman and Ms. Rubio. How much time do you think you need to prepare for a jury trial? 30, 60, 90, 120?
Perhaps 45 to 60 days, Judge, kind of incumbent upon Ms. Garcia's ability to provide us with a final recommendation. So I'd kind of like to defer to her.
Mr.
Your
Guzman,
Honor,
let me hear from Mr. Guzman and then we'll hear from Ms. Garcia. Mr. Guzman, your thoughts?
I would agree with that, Judge. I would tell the court that I do have a couple of jury trials in June and I believe one jury trial in July. And I would also ask, Judge, that if our motion for a child custody evaluator is going to be denied because Ms. Garcia can make visits at the residences, I would ask, number one, if Ms. Garcia has already made visits to Ms. Sanchez's resident, because that is one of the reasons why we filed this motion for a child custody evaluator.
Mr. Guzman, I've made my decision based on the black and white letter request in the motion. You can always bring it up and tell the court that there's new information. I'm not taking that away. I'm just saying as of today, the way things exist right now, that's the best possible outcome at this juncture. You're requesting this jury trial. You don't have an objection to Ms. Rubio's request for about 45 to 60 days. Ms. Garcia, you were about to say.
nothing, Judge. That I've got no issue making home visits. Just to advise the court, I have been in constant contact, at least aside from Mr. Lessa going and having his detail in another state in the meantime. But I have spoken to both parents regularly, and I'll just leave it at that, Judge. I've got no issue making home visits.
All right. Ms. Flores, can you ascertain how many jury trials are scheduled on August 21st?
Let me look into it, Your Honor.
Unless you all want July.
That's a Friday, Judge. Do you typically start on Fridays?
Yes.
Okay. What's the July date?
17th.
I could do the 17th.
Any objection to July 17th, Mr. Guzman?
1 second, Judge. No, Judge, no objection.
All right, so let's work backwards. So, voir dire will commence on July 17th at 8 a.m. Your opening statements will commence on July 20th at 8 a.m. That's a jury trial. Ms. Flores, give us a no, I'm going to schedule a jury selection conference on July 7th at 2 p.m. That's the final date to announce any agreements, if any, because the notice is right after that. They're going to go out, and then we'll have already gone out to the veneer persons. And now give us a final pretrial hearing in June, Ms. Flores.
June 18th at 9 a.m.
I'm going to order that all persons attend mediation before July 2nd. All right, let me put that all on the record sequentially. Final pretrial hearing, June 18th at 9 a.m. Mediation must take place on or before July the 2nd. Jury selection conference, July the 7th at 2 p.m. That's the final date and time to announce an agreement, if any. Voir dire then commences on July 17th at 8 a.m. with the jury trial and opening statements beginning on July 20th at 8 a.m. Thoughts, comments, questions, or objections, Mr. Guzman?
No.
Same question, Ms. Rubio?
Will you be appointing a mediator or shall we confirm?
It's always preferable that you all agree, but I can appoint someone if you don't. Mr. Guzman, Ms. Rubio, is there any person that you can agree to?
Judge Hale?
I would agree to Judge.
You would agree? All right, so ordered. Who will be preparing an order with the appointment of Judge Hale?
We can do it, Judge.
Thank you, Mr. Guzman. These are the orders of the court that are due to the court honor before
May 18th at noon by submission.
Mr. Lessa. Do you have any questions for the court?
No, sir.
Ms. Sanchez, do you have any questions?
No.
Anything else on this case, Mr. Gonzalez?
No, Your Honor.
Ms. Garcia?
No, Judge.
Ms. Rubio?
No, Judge.
Mr. Guzman?
No, Judge.
Good luck to everyone.
Thank you, Judge. That's all I have. Maybe excuse.
Good to see you both. Have a great day.
Thank you, Judge.
Next case, Your Honor, the PM docket, page 3, number 7, with Attorney Juan Basan.
Ileana Cedillo versus Delilah Carranco, cause number 2023 FLK 366C3. Mr. Basan, are you present?
Good afternoon, Your Honor. Yes, I'm here.
Welcome to court, Mr. Basan. The court marks you present. You're participating by video conference. Speak in front of the microphone and tell the court, are you Ileana Cedillo?
Yes, Your Honor.
Welcome to court, Ms. Cedillo. The court marks you present in person. Are you Delilah Carranco?
Yes, Your Honor.
Welcome to court. The court marks you present. You're participating by video conference. Ms. Carranco, do you have a lawyer?
No.
Are you going forward without a lawyer?
I would like to ask for more time so I can get a attorney.
This is a first setting on a motion to transfer. What say you, Mr. Basan?
Your Honor, respectfully, we're going to be in objection to that, Judge. Ms. Carranco has had ample time, Judge. We filed this case quite some time in Hidalgo County. Judge, we're ready to proceed with Ms. Cedillo if the court needs to hear testimony. But simply the issue today is just whether or not we can transfer the case from Webb County to Hidalgo County, depending on the court's ruling. Ms. Carranco still has time to retain a lawyer. I don't anticipate we're going to be hearing anything in regards to the pertinent issues that we are going to be requesting in the future. Solely, we just ask if we could entertain our motion to transfer this afternoon.
I was reviewing the case file in this case. So the court has seen that a motion to transfer venue was filed with court February 9, 2026, together with an affidavit for change of venue. Now, pursuant to the rules of civil procedure and the family law code of the state of Texas, once a respondent is served with that document, they have 20 days to file any controverting affidavit. I see that service was effectuated regarding that motion to transfer on February 10, 2026. I take judicial notice, this court does, that no controverting affidavit has been filed, but to be absolutely certain, let me ask the district clerk's office, is there any controverting affidavit on file?
No, Your Honor.
All right. So normally, in normal situations, all things being equal, Ms. Carranco, by policy of the court, this court does grant additional time to hire counsel. However, in this situation, it's the rules of civil procedure and the Texas Family Code that apply to the situation. I don't have any option. And this case hereby transfers to Hidalgo County. The court is going to order that all pleadings in this proceeding, copy of the entries of the minutes, a certified copy of the final order, certified copy of this order transferring this case to that court, and other documents filed into this case be sent to Hidalgo County. The court has signed an order to that effect. Mr. Basan.
Yes, Your Honor.
Any questions or anything else on this case?
No, Your Honor.
Ms. Cedillo, do you have any questions for the court?
No, Your Honor.
Ms. Carranco, do you have any questions for the court?
No.
Okay, I wish all persons well. More importantly, I wish this child all the best. Good luck to all.
Thank you, Judge. May we be excused?
Yes, have a good day.
Thank you, Judge. It was a pleasure.
Next case, Your Honor, Attorney Alonso Ramos, Edward Dancos, page 2, number 3.
Elsa Gomez versus Andres Jorge Gomez, cause number 2018 FLA 2421C3. Alonso Ramos, Edward Dancos, Claudia Garcia. Any lawyers present?
Yes, Your Honor, I'm here.
Court marks Ms. Garcia present by video conference. Mr. Dancos also present by video conference. Mr. Raul Gonzalez here on behalf of the AG's office by video conference. Elsa Gomez, Andres Gomez. Any parties present? Court finds no parties are present. Ms. Garcia, this is your motion. Go ahead.
Yes, Your Honor, I filed a motion to withdraw. I've conferred with my client a few times. The issue here is payment of my fees, Judge. I've done a lot of work in this case, more than what the retainer I've quoted entailed. I've asked for additional retainers and my client is just not able to make that payment, Judge. So unfortunately, you know, as private attorneys, we can't continue working without the security of payment for services, Judge. And in this case, it's a highly contested matter. And so I'm not able to continue with my services at this time, Judge. So I would ask to withdraw.
Thoughts, comments, questions, objections, Mr. Dancos?
We have no objections to her removing herself from the judge.
Same question to you, Mr. Ramos. Please unmute your device.
Judge, I hope you can hear me. I apologize. No objections, Judge.
Mr. Gonzalez?
No objections, Your Honor.
Mr. Gomez, you heard the request of your lawyer. Do you have any objection to that request?
Your Honor, at the moment, no. I signed an original contract and yes, I mean, yes, I'm unable to provide an additional retainer. So no, sir.
All right, the request is well taken. The court has signed an order withdrawing Ms. Garcia. Any other cases for Ms. Garcia?
That is all, Your
No,
Honor.
Judge.
Have a great day.
Thank you, Judge. May be excused.
Yes.
Thank
All
you.
right, so
Thank
the
you, Judge.
withdrawal,
Thank you, Judge.
no one is excused.
Oh,
The
sorry.
withdrawal is granted. Ms. Flores, does the court have Mr. Gomez's email address?
No, Your Honor.
Mr. Gomez, what is your email address?
Oh, it would be AGOMEZ 9460 at gmail.com, sir.
Say it one
Your
more
Honor.
time. One more time, just in case we missed something. Go ahead.
Of course. A Gomez 9460 at gmail.com, Your Honor.
Mr. Gomez, look out for in your emails, because if the court needs to send you any information, any notices of setting or any request, whatever the case is, if the court needs to communicate with you, it will go to that email address. Likewise, if Mr. Dancaus or Mr. Ramos, on behalf of Ms. Gomez, need to send you any information, requests, or documents, it's going to go to that email address, so they can serve you there. Do you understand this, Mr. Gomez?
Yes, Your Honor.
We're set to go for a final hearing on June the 16th. Will you be looking to hire a lawyer before then, Mr. Gomez, or do you think you're going to go forward without a lawyer?
I'm actively looking for somebody, Your Honor. I just didn't have enough time already, since this happened, last minute. And then while I was waiting for this hearing on the results, I still reached out to Ms. Lanese all the way up to last Friday, but she expressed her concerns. I don't understand them. I've paid everything that she's requested, but I understand that. So I will be trying to seek an attorney, sir. Your Honor.
Yes. Mr. Dancaus, did you want to say something?
No, yeah.
Oh, thought you were trying to say something. All right, then we'll come back on June the 16th at 2 p.m. If you do hire someone, please do so as soon as possible so that that person is ready to help defend your case. Anything else on this case, Mr. Ramos?
No, Your Honor.
Mr. Dancaus?
Thank you.
No, Your Honor.
Mr. Gonzalez?
No, Your Honor.
Any questions for the court, Mr. Gomez?
No, Your Honor, not at the moment.
All right, good luck to all. Thank you all.
Thank you, Judge. Thank you, Judge. Have a good
Thank
day.
you, Judge.
Likewise.
Yes.
Bye-bye.
And Judge, may I be excused?
Yes, sir.
Next
Thank
case,
you.
Your
Have a
Honor,
great
the AM docket. This will be Attorney Marcel Knudsen. Number one.
This is Tanya Elizabeth San Miguel Alberto Pina, cause number 2011 CVG 2217C3. Court marks Mr. Eustorgio Perez present in person, Mr. Marcel Knudsen present in person, Raul Gomez on behalf of the AG's office present by video conference, Tanya San Miguel present in person with her lawyer, Alberto Pina present with his lawyer in person. Counsel, go ahead.
Yes, Judge, we took to heart what the court said and keeping in mind the best interest of the child. The parties have come to an agreement. I'd like to announce it on the record, and Mr. Perez can announce if that's accurate.
Go ahead.
Okay. First of all, party of the agreement and a material part of the consideration for my client that the child will go to see Jesse Hernandez. I think he won't be available until sometime within the next 2 weeks on at least 2 visits, and just to perform tests, make sure that the child is fine and safe, and any additional visits that he may require as being in the best interest of the child. My client will be fully responsible for paying any out-of-court cost. Number two is that there is a past due child support arrearage of $4,967.98. And my client's father is going to get that paid today. I have a check dated May 5th, 2026, payable to Tanya San Miguel for says back child support and medical support. The Attorney General at the last hearing had agreed that we can make the check directly to her. We have copies of that, and we will send him a copy of the check. And once the agreement is approved by both sides, I will tender the check payable to Tanya San Miguel to her attorney, Topo Perez, who in turn will turn it over to her. And we'd ask the court to acknowledge once that's the court observes that happen. Next, basically, the child had expressed a desire to primarily stay with the mother, so my client is going to accept those wishes. Currently, she didn't want to have overnight with the dad. That was discussed at length, but he's willing not to have overnight for the best interest of the child and let that happen as things evolve. Basically my client also has will agree to have the child insured, which he's had for the last 2.5 years that he's had primary custody. So he will continue to do that until the child turns 18 years of age. When's her birthday?
October 28th.
October 20th. So she graduates before she turns 18 or? Or before she turns 18? Okay. So basically, my client was entitled to claim the child on the tax return for 2025 because he was the primary conservator. She claimed him, so he's not going to contest that, but she has agreed that my client will be able to claim the daughter for 2026, which is this year, 2027, 2028. Then neither side can claim the child unless she goes to college, and whoever provides over 50% of the support for college can claim the child. You know, basically, and I think this is important, Judge, that neither parent shall say any derogatory remarks about the other parent or their family. I think that unfortunately was a big cause of the, anxiety of the child and, other issues that are not in the best interest of the child. I don't want to elaborate, but, we would want that in the order. My client has also agreed to pay $500 a month child support starting June 1st, 2026. He's paying the $4,967.98 today. And have I left anything out, Mr. Pettis?
Not so far.
And basically, I believe is there anything? I think that's it, Judge. I do have a check here. I'll tender it to Mr. Pettis. And I would ask the parties to be sworn and ask if that's their agreement.
Mr. Perez,
I have nothing to add.
Mr. Gonzalez.
Yes, Your Honor. I would like to get the judgment on the record. I know that they are going to be paid, but I want to be completely clear on that. I believe Mr. Knotson said it, but I want to give the exact amounts because I believe there's going to be an offset for our record.
Let me ask you that. I agree with you, but let me ask you this. If the court takes a judgment right now, and then there is a check that is being tendered in court to satisfy that judgment, how then, are you going to just take notice right now that there should be that? How is your office going to get that record so that Mr. Pina has proper credit?
So what usually I'm not aware of what the attorney said in the previous hearing, but usually that payment is done through the Office of the Attorney General. Pretty much it's paid to the Office of the Attorney General because there's also medical support arrears that are owed. Once that goes through, then the payment would go to Miss San Miguel. I'm not sure
I think that's my point, Mr. Gonzalez. In this situation, it's different. In this situation, Council 1 is tendering to Council 2 a check, and I'm concerned that at some point this thing is going to come back because your office hasn't been properly notified. My question is how do we account for this exchange?
And Judge, I did talk to the attorney earlier, and he gave me this amount as of April 30th, and the parties have agreed that'll, basically, cut anything off. And so there'll be a zero judgment that she owes medical support. There'll be a zero judgment that my client owed, I think, 167 in medical support and 4,000 or 5,200 in child support arrearage, and she owed 400 in medical arrearage. The offset, the net was 4,967.98, and that's. I talked to Mr. Gonzalez today about that, and that's how we got that. And I will send him a copy of this check, and then with the order that we prepared, it'll say, as of April 30th, 2026. Neither side owes anyone anything. It's a zero judgment on both sides for any child support.
All right. So let's do this, Mr. Knotson. What is the check number that you are tendering to Mr. Pettis?
847, and it's from his father.
Check 847 is in what made out in what amount?
$4,967.98.
Tender that to Mr. Pettis.
There you go.
Mr. Pettis, can you both confirm the check number and the amount?
Correct, Your Honor.
All right, the court has heard it is correct. So let's do this and the Attorney General can ask questions momentarily and object if necessary or opine either way. Ms. San Miguel, Mr. Pena, raise your right hands, please. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Yes, Your
Both
Honor.
have answered yes. You may lower your hands. Is your true and correct name Tanya Elizabeth San Miguel?
Yes.
Ms. San Miguel, you're present in person. The person to your right is your lawyer. Did you hear and understand the agreement that was put on the record and told to the court by Mr. Knotts and Mr. Pena's lawyer?
Yes.
Is that your agreement with Mr. Pena?
Yes.
Is that your full agreement?
Yes.
Was anything left out?
No.
Is there anything you want to change?
No.
Do you believe that this agreement is in the best interest of your child?
Yes.
Mr. Pena, you are also under oath. Is your true and correct name Alberto Pena?
Yes, Your Honor.
Mr. Pena, you're here in person with your lawyer who is on your right. Did you hear and understand the agreement that was told to the court by him?
Yes, Your Honor.
Is that your agreement with Ms. San Miguel?
It's true.
Is that your full agreement?
Yes.
Was anything left out?
I want to make that telephone calls communication between our daughter stay between with the app close that we have.
App close is usually for the parties, not between the child.
Oh,
Mr.
for the parties, and he will, she has a phone, so he'll continue, I forgot that part, call her on a daily basis and,
I just want to make sure I understand. So the modification or the additional agreement is a communication between the parties be through app close, but communication with the child is just through regular electronic means?
That's correct.
Mr. Nelson?
yes.
Mr. Pettis?
That's correct, Your Honor.
All right. Other than that, that has now been incorporated and confirmed, Mr. Pena, is that your full agreement with Ms. San Miguel?
Yes, Your
Was
Honor.
anything left out?
No, Your Honor.
Is there anything you want to change?
Not at the moment, Your
Do you
Honor.
believe that this agreement is in the best interest of your child?
Yes, I do.
And Judge, I don't know, Mr. Pettis wants to add anything or?
Just to ask her if she ever speak the corrections of the communication.
Go ahead, Mr. Pettis.
Did you hear what the Mr. Malcolm stated, the presentation?
Yes.
You have text of that and the deed.
Yes.
Are you anything?
Yes.
And the last thing, Judge-
Give me 1 second. Mr. Gonzalez, let me give you an opportunity to ask questions of either or both of these parties, one at a time. Mr. Gonzalez.
Yes, Your Honor. The first thing I would like to do is that I would like to object to the form of payment. All payments for child support needs to come through the state disbursement unit. So the payment can go through, it can be paid today, but it needs to be paid to the child support office. Otherwise, we're not going to have a record for it. If that check happens to bounce or it doesn't go through, we're not going to have evidence of that. In order to have proper evidence, in order to have everything on our financial record, we do need the payments to go to the Office of the Attorney General. I would like to give you the exact numbers, Your Honor. I believe I did give those numbers to Mr. Knotson. And I just want to go through with them. So there is so it's for the record. We also did file the financial activity report this morning for this case. So the child support judgment was of $5,246.90 as of April 30th, 2026. The medical support judgment was $163.97 as of April 30th, 2026. So the cumulative judgment owed by Mr. Pena, it's $5,410.87. Now, in this case, Ms. San Miguel owes $442.94 that's owed. Therefore, the offset would be a total of $4,945.22 as of March 31st, 2026. That's the exact amount. I believe Mr. Knotson said it. I just think at the very end he put an 8. I'm sorry, 490. The total amount that's owed is 4,967. I apologize. I read the wrong thing onto the record. The child support judgment is.
Give me 1 second, Mr. Gonzalez. Speak slow. I'm writing stuff down. I just want to make sure that we have a good and accurate record. Just no rush.
Yes, Your Honor.
Slow down. Go ahead.
I apologize, Your Honor. I'm going to restate what I mentioned.
Go ahead.
The child support judgment is $5,442 $246.90 as of April 30th, 2026. The medical support judgment is $163.97 as of April 30th, 2026. So the cumulative amount owed by Mr. Peña is $5,410.87. Now, Ms. San Miguel owes $442.94. Therefore, there would be an offset, and the offset amount is $4,967.93. Now, we would have placed a payment plan of $75 for that. Mr. Peña stating that he's able to pay the entire amount right now. Therefore, we would just object to the form of payment. We would want that payment to go through the state disbursement unit, so we have an accurate record that the payment has gone through. And then, and the other thing that we had was just the medical support. And Mr. Knotson has already stated that Mr. Peña is going to carry private insurance for the child. And that's going to carry until the child graduates from high school or whenever they turn 18, whichever one's later.
That's correct, Judge. And just for the record, I know Mr. Gonzalez has a lot of cases, but when we were set for trial last week, when the court's internet went out, I talked to him and he said he was agreeable that it be paid directly to her, and it was a little bit less amount. So that's why we did it this way. He, and we are going to send him a copy of the check, and it will be part of the court order. And if in fact the check doesn't clear, which I'm confident it will clear, Mr. Perez will advise the Attorney General of that, and the court, and my client's going to owe it. So that's not going to be any issue there. And I believe Ms. San Miguel knows that the check of his father will clear. So basically, I think just to try to help, she could use that money to help with the child. I think that's in the best interest of the child, and with the court's order, it'll all get worked out, Judge.
Additionally, Your Honor, there's a policy with the state. My client is willing to give Mr. Pena any sworn statement indicating that she received this as full payment for the arrearage, and provide that Mr. Naughton confirm.
Mr. Perez, closer to the mic.
Again, go ahead.
Yes. Additionally, if need be, my client is willing to give Mr. Pena, through his attorney, any affidavit that she might need to provide to clear the payment with the state of Texas.
A couple of questions. First question both questions to Mr. Gonzalez. Mr. Gonzalez, is it then your opinion that a payment, to set aside where and how, but a payment of $4,967.98 would satisfy any judgment this court could take?
Yes, Your Honor, I would just make a change to the cents. It's 4,967 with 93 cents.
I put 5 cents extra, so I'm sure.
Mr. Gonzalez, second last, I think it's my last question. Mr. Gonzalez, the source and authority of the state's position that the funds should be paid to the state?
Yes, Your Honor. Yes, it would be. I don't have it in front of me, Your Honor, but it should go to the state. That's how we take the FINAs. That's how we can update our financial activity records, and that way make sure that procedurally everything goes well.
But remind the court the authority. Is it statutorily? Is it based on the order? Is it based on case law?
Let me look it up, Your Honor. I don't want to make any mistakes.
Sure.
If I may, Your Honor, I've done it plenty of times for the parties coming in. Receiving files says that she's satisfied and it's clear to the Attorney General.
And I've done the same, Judge, and I will state as an officer of the court, and I know Mr. Gonzalez, it was a very contentious case last hearing. He said the Attorney General would be willing, as long as it was stated on the record, have the payment made directly to her to get current. and that we would provide him proof of same.
I don't disagree with anything that any person is saying right now.
So I believe it's Texas Family Code 100 or section 154.004, Your Honor. I'm looking it up right now.
One more time,
154.004. So it's Texas Family Code 154.004, place of payment. So it's current as of January 1st, 2024. Section A state, the court shall order payment of child support, medical support, and dental support to the state disbursement unit as provided by chapter 234. I'm seeing if there's, if it's not being enforced by the Title 4, the 4D agency. So I do believe the state would ask for that, Your Honor. Now, I guess the only workaround I could see would be if all the retroactive support that's owed to her would be forgiven today, but even then the medical support would still remain. So I do believe, it's going to be a couple of more days that Miss San Miguel would have to wait in order to receive her funds. But I do believe this is the safest option in order to make the payment.
all right, Mr. Perez, Mr. Knudsen, Mr. Gonzalez, Ms. San Miguel, Mr. Pina, I unfortunately, I guess fortunately, I know the answer. I learned this one the hard way. And Mr. Knudsen, Mr. Perez, I, on a personal level, my judicial philosophy agrees with your position. I think that parents have the right to say how best to dictate the payment of child support. I believe that is a constitutional right. When asked in about 2018, that same question, I, over the objection of the Attorney General's office, allowed exactly for this to happen over their objection. Because I thought when parents know their situation best and their child's situation, and if this money goes directly to the receiving parent for the benefit of the child, certainly that is in their best interest, and no person could reasonably argue that that isn't in the best interest. When appealed, the fourth court said we were all wrong. I'm not doing that again. Mr. Gonzalez is correct. So the court hereby adopts and approves the agreement and finds that $4,967.93 would satisfy the judgment that the court hereby takes. Put that into the order, pay it to the Attorney General's office. That way, when the funds clear, the judgment would be satisfied. Mr. Gonzalez, have I missed any steps?
That's exactly right, Your Honor. Thank you.
All right,
Mr.
Judge, with that,
Knudsen?
That's fine. We'll have to get another check and we'll make it payable to the Texas Attorney General.
Yes, Mr. Knudsen. So I could, there's a section that says on the Texas Attorney General website, it says pay by mail. And you can make your check or money order payable to the state disbursement unit. And it has the address and everything that needs to be on the check or the mail or the envelope.
I think I had another case. It was Texas SDU. Is that correct?
State disbursement unit, SDU, PO Box 659791.
We put the name of the non-custodial parent, Alberto Pina, based on our agreement today. NCT.
Yes. So you would put
we'll put the OAG number, or do we put the case number?
you would put both, Mr. Knudsen. You would put the 10-digit OAG number the cause number for this case, the name, the full name of Mr. Peña and the full name of Ms. San Miguel.
Okay, well, we'll see if all that squeezes in there. Maybe so.
I guess the only question that the court has, Mr. Gonzalez, I would presume that the OAG's office has no inkling or preference as to who makes the payment so long as it's made, right? In other words, if the same check is made payable to the OAG's office, even though it's not made by Mr. Peña, the funds would still be accepted?
I believe so, Your Honor. I am not a financial person, so I don't know 100%, but I believe so. As long as it has the proper information, the payment is being made. I believe it would go through.
All right, the court hereby takes that judgment in the amount of $4,967.93. The court finds that that amount satisfies, would satisfy the arrears. If there are any other arrears, the court finds that Ms. San Miguel hereby relinquishes those. These are the orders of the court, and the orders are due to the court honor before.
May 18th at noon by submission.
Thank
Do you have any questions for the court, Mr. Peña?
No, Your Honor.
Ms. San Miguel?
No.
Anything else, Mr. Perez? Mr. Knudsen?
No, I'd like to thank Your Honor for helping us work with this. I would just ask the court to admonish both sides not to talk about the case, the evidence that we presented to the court, to put either parent in a false light, and that's very important not to put any stress on the child. We understand that.
Put similar language into the order, that way each of you can advise your clients, not to, and it'll be mutual, but just always, and I'm sure you will, but for what it's worth, Ms. San Miguel and Mr. Peña, just be respectful with each other and always act in your child's best interest. I'm sure you would, but I'm going to put it in writing just to make sure that that is in fact the case. Ms. San Miguel, Mr. Peña, oh, Mr. Gonzalez, I didn't give you the opportunity. Anything else to put on the record?
No, Your Honor. Thank you.
You are correct on this one. Absolutely. Ms. San Miguel, Mr. Peña, I wish you both well. More importantly, I wish your child all the best. Good luck to all.
Thank you, Your Honor.
Maybe excuse?
Yes, have a good day.
Thank you.
Last case, Your Honor, the PM docket. Page 5, number 14.
Derek Hale, Sylvia Hale, cause number 2026 FLA 619C3. Court marks Mr. Vela present in person, Mr. Chu present in person, Derek Hale present in person, and Sylvia Hale present in person. Yeah. Court has heard that there was 5 contested issues. This is your request, Mr. Chu. Mr. Chu, we have a hard stop today at about 4:30. Are you ready to go forward?
Yes, Judge.
All right, who is your first witness?
I call Miss Sylvia Alicia Hale.
Ms. Hale, step in front of the lower bench, pull a microphone up to your mouth. Raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yeah.
You may lower your hand. You may have a seat here on the witness stand. As you have a seat, bring the microphone as close to your mouth as possible. Lawyers are going to ask you some questions. Don't answer the question until you've heard the full question. If you hear one of the lawyers make an objection, pause. I'll let you know if you can answer. Make sure you understand the question before you answer. You are under oath. Do you have any questions, Ms. Hale? Let's turn on that microphone, please. Do you have any
No,
questions?
Judge.
All right, Mr. Chu, whenever you're ready.
Please, the court. Would you please state your full name for the record, ma'am?
Sylvia Alicia Hale.
And are you married to Mr. Derek Andrew Hale?
Yes,
When did you get married to Mr. Hill?
March the 3rd, 2023.
And when did Mr. Hale file the divorce petition?
April 20th, 2026.
And where has Mr. Hale been living?
I don't know.
Has he been living the home with you?
No.
Where do you reside?
504 Placido Drive, Laredo, Texas, 78045.
From your marriage to Mr. Hale, how many children do you have?
2.
What are their names and ages?
Nika Valentina Hale, she is 2, and Oliver Forrest Hale, he's 6 months old.
Do you have any other children?
Yes, Isaac Nathaniel Guerra, he's 13, and Ellie May Saldana, she is 9.
And those are not the children that you have with Mr. Hale, right?
Right, not with Mr. Hale.
They're from a previous divorce.
Yes,
Okay. What is it that you do, Mrs. Hale?
I work for the federal government. I'm an agriculture specialist under DHS.
And what is one of the reasons,
Judge, I'm sorry, I just turned and I noticed there's a witness in the courtroom. If he's gonna be called as a witness, I would invoke the rule. If he's not, he can remain in the court.
he will not be called as witness, Judge. This is temporary.
Understood.
And what is one of the reasons that led up to the filing of this divorce?
I had a concern for my husband's aggression and the way he was treating the kids.
Okay, well, let's tell me about that. I mean, explain to us about the aggression and specifically as to which child.
I have noticed, I've witnessed the behavior with more so the baby, Oliver Forrest Hale. Ever since I think we brought him home, he was in the NICU for 7 days. And then after that, just strange anger towards the baby for moving a little too much while feeding, telling the baby to shut up while he was crying. And that was in front of me and all my children in a hotel room. So that, and then just kind of aggressively, changing the baby. And so I was explaining this to my therapist because I see a therapist regularly. And based on what I was explaining to her about the anger issues and how one time he was caring for Oliver alone, he got angry and punched a hole in the door. And how do I de-escalate?
When did this occur?
Oliver must have been, I don't know, 2, 3 months old.
Has any other those type of incidents happened after that?
Punching holes in the walls?
Yeah.
Not after, but prior.
Okay. And what else concerns you?
Drug use.
Okay, explain that. What kind of drug use?
Illegal drug use. That also came about in the CPS case because the report came in as possible domestic violence as well, along with the abuse to the 4-month-old concern. And then possible substance use. And that's where it came out that he was starting to deny drug tests and not comply. So that was concerning to me naturally with what I do for a living. So
why does that concern you again, Mrs. Ham?
because there's a 0 tolerance policy for drug use for federal agents.
Okay.
I cannot be associated. So just like my spouse cannot hire any legal housekeeper, I will also suffer the repercussions of that. So if he's engaged in illegal substance use, I am implicated to that, or I need to make sure that I show that I'm not complicit with that behavior, which is why this is important that I.
When were you made aware of this drug use?
The denial of the drug test was concerning. And
when was that, Mrs. Ham?
shortly after the CPS investigation started. I'm not sure of the exact date.
When was that?
I'm not sure of the exact date, but it was shortly after the CPS investigation when it started.
Okay, on or about when? Was it this year?
Oh, this year, about a month ago or a couple weeks ago.
Okay.
Yeah, within the last month.
In April?
Yeah.
All right. And are you aware of what type of drugs your husband was using?
No, not when he denied the drug test. No.
Did you
And
later become aware of what type of drug he was using?
only when he wasn't complying with, I was called by the CPS investigator that they could not get a hold of
Judge, I'm
Mr.
gonna
Hale.
object to her testifying about what other people told her. Now that investigation is here to.
Sustained.
So don't testify to anything that you heard, just what you know and what you observed.
Okay.
Okay, so when did you discover what type of drug Mr. Hill was using, your husband was using?
It wasn't until he wasn't complying, he finally called the substance abuse counselor. Since he denied the drug test, he had to go for those services. When he called and made that call, he had now obtained a prescription for medical marijuana for a chronic pain diagnosis through a virtual telehealth appointment, but no medical evidence of this chronic pain.
Okay, and how does your husband behave under marijuana that you have observed?
I would not know. He's up and down.
Okay. How is your husband towards your other child, Nika Hale?
He is not as aggressive towards her, but if it's during his sleep or she's sick and she's coughing, I've heard him yell at her, stop coughing, what are you doing coughing? And I'll step out and say, hey, it's okay, let me help you because you seem to need some help, like not in a confrontational way, just to help him. But it's always escalated. So that's why my therapist was trying to help me into how to de-escalate with his aggression.
And Nika is 2 years old.
She's 2.
And Oliver is 6 months.
6 months old, yes.
Okay,
The CPS call came in when he was 4 months old, so 2 months ago, actually.
right.
Yeah.
Who takes care of Nika and Oliver now?
Me, I do.
Okay.
And my mother helps me.
Okay, how do you take care of them?
Myself. While I'm at home?
Yes.
Yeah.
How do you take care of them? You feed them, you bathe?
Oh, yeah, I feed them, bathe them, give them their medication, treatments if they need it, whenever they have this cough congestion going on with all these viruses, respiratory illnesses. Yeah, I do that.
Okay, and who takes care of them while you're at work?
My mother,
Besides your mother, who else?
that's it, myself.
Okay. Are they in daycare?
They are in daycare. That's another thing that was started because I wasn't comfortable leaving my son with my husband.
When did you put the children in daycare?
As soon as the daycare told me they had a spot, I put him in there.
When was it?
April 7th, 6th, 8th, the week of April 6th or 7th.
Okay. That is this year?
This year.
Okay, all right. And who pays for the daycare expenses?
I pay for all daycare expenses for both children.
Okay.
$330 a week.
Now, what did you find concerning after Mr. Hale filed the divorce in your home?
I noticed a camera was installed. I know he got into an altercation with my mother while caring for our kids while we were both working that day. And then a couple of days after that, got into an altercation with my dad. All instances, police were called and a report was made, and there's evidence of that.
What else did you find in the house when you came home? Did you find anything in your shoe closet?
Yes, I found bullets that were placed by my shoes and isolated. That might be.
No, you said you're a federal agent.
Yes.
Are you issued a service weapon?
No, sir, I don't have a service weapon.
Okay.
So to my knowledge, there should not be a weapon in the home.
Okay, so Why are there, I mean, what did you find in your shoe closet?
9mm bullets
Okay. And,
placed right by my shoes.
and this
They
is,
were not there before.
okay. And this was your shoe closet or the closet that you share with your husband?
We share it. It was placed on my side of the closet where my shoes go.
Have you ever seen these bullets around anywhere else?
No,
Okay. What went through your mind when you found this?
I was scared
Why?
because he has been unstable in the past with his aggression and then also with suicide concerns. And I didn't know if he was going to do something to himself or do something to me or the kids. And I have made sure that I have not been by myself ever since I saw those bullets.
That's why you have your parents with you.
Yes, I'm never alone. They will not leave me
Okay.
either.
Now, besides the children in your house, do you keep animals?
Yes, we have 5 dogs,
Okay, what type of dogs are they?
3 Great Danes and 2 mixed breed dogs.
And where are the dogs kept?
504 Placido Drive, the property.
Okay, are they indoors or outside?
Both. So mostly indoors, go outside to use the restroom.
Okay, so how do you juggle taking care of 5 dogs and 4 kids?
It's a challenge because they all don't get along. So it's like musical chairs moving from crates to outdoors to a restroom, from restroom to crates to, and it's with the heat, I'm worried because I've been threatened already to have the cops called on me for the dogs. I'm worried that with the heat, an accident might happen and then I'll be at fault for something that was not intentional. And
What do you
it's a
want
lot.
done? What do you want done with the dogs?
At the very least, to please take the 2 that he had prior to the relationship. I'm fine with staying the 3 Great Danes. But at least the 2, so that way I can mediate with the other ones.
What are you asking the court to do with the residents during this time of the divorce?
To allow me and my 4 children to stay in their home.
And what are you asking for visits as it concerns for Nika and for Oliver?
I would like supervised visits
And okay, why is that?
because I feel since the CPS case, he has shown more of this instability or mental instability, and it's concerning some of the behavior that has happened since.
Pass away.
Cross-examination, Mr. Vela.
Ms. Hale,
Yes, sir.
you've been married to Mr. Hale for 3 years, correct?
Yes, sir.
And Mr. Hale is the one who filed for the divorce in April 20th of 2026.
Yes, sir.
And prior to Mr. Hale filing for the divorce, you had frequently allowed Mr. Hale to care for the children on his own without any supervision. Isn't that true?
I had no other choice. I was the breadwinner and I needed to work.
And I'm going to remind you that you're under oath today, okay?
Yes.
And you swore to tell the truth.
Yes.
You've allowed Mr. Hale to take care of the children throughout the entire 3 years of your marriage on numerous occasions without any supervision. Isn't that true?
Yes, I have.
Okay. And in fact, prior to him filing for the divorce, you allowed him to take care of the children unsupervised while you went out of town. Isn't that true? For 2 nights.
Hesitant, yes.
Right?
But hesitant, yes.
And despite already knowing that you had these concerns about CPS and about your claim that he was abusive or that he had drug problems, you allowed him to take care of the children unsupervised for 2 nights, correct? In March.
Because I was threatened a lot by him and I did not want to jeopardize anything in the future. So I felt like with my job, I have to take care of how I behave. So I wanted to make sure that I was also trying to give the kids an opportunity to spend time with their father. But as time passed, like I mentioned, his behavior became more and more bizarre.
Okay, so my question was specifically about March of 2026.
Yes.
2 nights that despite you knowing all these things that you told the court, you allowed Mr. Hale to take care of the kids unsupervised. Isn't that true?
His mom was usually there.
But
yes.
my question, ma'am, listen to my question. My question is you allowed him to take care of the children unsupervised for 2 nights, right?
Yes.
Okay. And is it you who reported the call to CPS about your concerns about Mr. Hale?
No, sir.
was it your therapist that you're seeing?
Yes,
Okay, and you're also claiming that Mr. Hale's unstable, but you're the one who's actually seeing a therapist. Isn't that true?
therapy doesn't mean you're unstable.
Well, but you're seeing a therapist, correct? That was my question.
Yes, I'm seeing a
Okay.
therapist.
And what kind of medications do you take as part of your therapy?
I don't have any medications.
No,
No, sir.
you do not. Okay.
No, sir.
Now, you mentioned to the court that you found some bullets in your closet. Did you file a police report about the bullets?
I did mention to the police and that I have photos.
Did
Yes.
you file the police reports with the bullets?
No, I have not filed a police
Okay.
report. I wasn't sure how to handle that situation.
And you don't have a service weapon?
I do not have a service
And
weapon.
Mr. Hale doesn't have a service weapon?
He's owned a gun in the past, but I was told it was sold.
There is no weapons in your house?
Not to my knowledge, but there might be.
And in fact, Mr. Hale has tried to reach out to you in this past month to go see the children and you have refused.
I don't feel that they are safe.
Okay, you have refused, correct?
Correct.
Okay, and you do not have a court order that says that Mr. Hale cannot see the children?
No, I don't.
And he is the father?
Yes, he
Okay.
is.
And you have trusted him for 3 years to take care of your children on multiple occasions, correct?
Yes.
And in fact, you have posted multiple times on the internet, on your Facebook chat, that Mr. Hale is a godsend to you and to the family. Isn't that true?
I feel like I need to elaborate.
Okay, Judge, may I ask the court to call up on case lines petitioner's exhibit number 6?
Court staff will prompt.
And I'm going to ask you, you go by the name of Sylvia Alicia on Facebook, correct?
Yes.
And on March the 9th, 2024, you posted this post that the court is showing you, correct?
From 2 years ago, yes.
Yes. And I want you to read it so that the court can understand the things you were saying about Mr. Hale, okay?
Objection, relevance, Judge.
Relevance.
Judge, she is attacking my client's reliability and ability to care for the children and that he's a monster. And so these messages that she's going to read are going to tell you what she feels about her husband on different occasions to rebut her allegations today, Judge.
Judge,
Oh, go ahead.
that's when Nikita was just born and before Oliver was born, Judge. It was 2 years ago.
Overruled. You may answer.
Please read what the court is showing you on petitioner's exhibit number 6, which is a post you made on March 9th, 2024.
What a ride this month has been, and as always, time is a thief. Every minute with you, baby girl, is complete bliss. Your smiles, snorts, and farts make every day a dream. Thank you, Hellboy, for always taking care of our family and me. May God continue to bless our family, and may we enjoy many, many more months together for all of eternity. Happy 1 month, Nika Valentina, mi chiquita preciosa, te amo, mami.
And when you said, thank you, Hale Boy 92, for always taking care of our family and me, who are you talking about?
I'm talking about my husband.
Okay. Now, let me show you exhibit number 7. Judge, may we ask the staff to call up petitioner's exhibit number 7?
Court staff will prompt.
Now, in June of 2025, you posted this on your Facebook, Sylvia Alicia. And this was a post that you were posting to who?
My husband.
Okay. And can you read what you said about your husband back in June 15th, 2025?
Yes, to the man who didn't just step in, he showed up with his whole heart. You love our babies with every fiber of your being, and you've wrapped my kids in the kind of love they will never forget. I see the sacrifices, the late nights, the gentle hands, the loud laughter, and the quiet strength. Thank you for being the kind of father that heals, builds, and loves without limits. We're so lucky to call you ours. Happy Father's Day.
And this was in 2025. And now you're telling the court that all of a sudden, Mr. Hale, he can't have the kids because he's a danger to you and to the kids. Is that what you're saying?
Yes.
And you're also saying that Mr. Hale is unsafe.
Yes.
Okay. And Judge, may I ask the court staff to call up exhibit number 8?
Court staff will prompt.
Am I allowed to elaborate at all?
No, your lawyer will be able to ask you some questions to follow up, Mr. Vela.
Now, you've told the court that back in March is when the CPS phone call came in, when your therapist made a call against my client. True?
Yes.
Okay. And so since March, you've known about whatever issues you're concerned about with Mr. Hale.
Yes.
And despite that, you allowed him to care for your kids unsupervised while you were at work. True?
I had no other choice. Yes.
The question is, did you
Yes.
allow him?
Yes.
Yes. Okay. So now let me show you what's been marked as petitioner's exhibit number 8. This is a message that you sent to my client. Sylvia Davila is your name?
Yes.
Okay. And read to me the parts that are in black, and I will read the parts that are in green, which are my client's responses to you. Start at the top, please.
Hug and kiss the babies. Good night for me. Good night. I hope the babies are easy on you. Good night. I fell asleep putting Nika to bed. Now I'm up because she's coughing again, giving her meds, then going to sleep. Neighbors are partying with the jump house since 2
And
p.m.
who is talking in the sections that are green?
Mr. Hale.
And who's talking in the sections that are black?
That would be me.
Now, continue, please.
Yikes. I have my phone on loud in case you have an emergency. Thank you for taking care of Nika's cough. Sounds like nighttime makes it worse. I hope the neighbors stop soon. Try to get some rest. Oliver gets up between 5 to 6-ish, sometimes 7. Good night. Missing you guys.
And then what does he respond? Mr. Hale.
Oliver is up right now. Gonna feed him again. Nika is up from coughing again. Had to give her medicine. She's back asleep since I've been trying to get Oliver back down.
So in this message, which was on March 29th, 2026, just almost 35 days ago, despite you knowing that CPS had been called, despite the fact that you're claiming my client was somehow abusing a narcotic, even though he had a prescription, despite the fact that you're telling the court that he placed bullets in your closet, you were still allowing him to care for the kids while you were at work.
That happened after this,
well,
message.
What's the date of this message?
March 29th. I'm saying the bullets happened after this message. Behaviors changed after that message.
So exclude the bullets part. Even though you knew that your CPS had been called, that you were claiming he was aggressive towards your child or your children, actually, and that he was somehow a danger to you, you allowed him to take care of the kids unsupervised.
I
Yes?
allowed him to take care of the kids unsupervised. I will also say that during this time, and Mr. Hale can attest to this.
No, ma'am. I just asked you if it was true. You can stop there. Yes or no?
Yes.
Okay, thank you. Now, here on this exhibit, which was petitioner's exhibit number 8, March 29, 2026, my client is telling you that he's going to feed Oliver. So he knows how to feed Oliver, correct?
Yes.
And he knows how to change his diaper?
Yes.
And he knows who the doctor is?
Yes.
And your baby feels comfortable with him because you've left them with him multiple occasions?
Correction. I think he knows 1 or 2 of his doctors. Yes.
Okay. And then with regards to Nika, your 2-year-old, the same thing. He knows how to feed her? Yes?
Yes.
He can take her to the doctor if she's sick?
Yes.
He knows how to give her any type of medicine that she needs?
He's made mistakes, but yes.
Okay. And after the divorce was filed, which was on April the 20th, 2026, according to your testimony, that's when you decided that my client was no longer going to be able to visit with the kids.
I will say during this time, we were doing marriage counseling. And so I was fighting tooth and nail for this marriage. So I was trying to provide the words of affirmation he was asking for, which will lead to all these sweet text messages, because that was how my client received love. So I was doing that for that reason. But since the filing, that changes how I have to approach the way I'm truly feeling about my concerns.
And so your answer is yes. After the April 20th filing, you decided you were no longer going to let Mr. Hale see the kids.
It was before the filing.
And you also decided that you were not going to let Mr. Hale go into the house.
Correct.
And the house was purchased during the marriage.
Yes.
And it was purchased let's see. On exhibit, I would ask the court to call up exhibit number 5, Judge.
Court staff will prompt.
I'm sure what's been marked as petitioner's exhibit number 5. It's a copy of the general warranty deed. And on the first paragraph, it says that this property was granted to grantors paid by Sylvia Hale and Derek Hale, husband and wife. Is that true?
Yes.
And if I can ask staff to turn to page number B7, Judge. And this document can you go down to the signature? This document right above the signature says December 15th, 2023, correct?
Yes.
And so this property was purchased in both of your names.
Yes.
And you and your husband both have the right to live at this home, correct?
Yes.
Unless the judge says otherwise.
Right. Yes.
But despite the fact that it's in his name, you have not allowed him to go into the home.
We agreed that he wouldn't go in at the beginning. Yes. And then the TRO was filed.
So you actually asked him to stay out. Yes?
We agreed that it was best because I had 4 children and he was one person.
Okay, so you asked him to leave the house. Yes?
Yes.
And he voluntarily agreed?
Yes, but then changed his mind.
Okay, and so now you want to keep him out.
Yes.
Okay. Now, let me show you petitioner's exhibit number 1. I would ask the court to, the staff could show exhibit 1.
Court staff will prompt.
That is your husband, Mr. Hale, with your children, correct?
Yes, taken when he was at our home by himself.
Okay. And may I ask exhibit number 2, Judge, if we could show that?
Court staff will prompt.
And exhibit number 2 is a picture of your husband with your older daughter,
Yes, that's Nika.
Nika. And exhibit number 3, Judge, if we could show that?
Go ahead, staff.
And that is your husband with your younger child, Oliver, correct?
Yes.
And he's feeding him with his bottle.
Yes.
And he's done that on multiple occasions while you're at work?
Yes, he's had to.
Okay. Judge, I'd like to offer petitioners exhibit 1, 2, 3, 5, 6, 7, 8. At this time?
Any objections to exhibits 1, 2, 3, 5, 6, 7, and 8?
We have no objection.
They're admitted without objection.
And then, Judge, may I ask if you could please call up exhibit number 9?
Court staff will do so.
In this particular exhibit, you are responding in black and Mr. Hale is responding in the blue. You asked them to leave some food outside because you didn't want them to go into the home. And Mr. Hale told you that you couldn't do this without a court order and you were prohibiting from entering the house. Is that true?
Prior to that message, it was his idea to leave the dog food outside. So I just said, okay, please leave the dog food outside to avoid confrontation, which ended up happening because he did not leave the dog food outside. He went inside and got into an altercation with my mother.
Okay, so that's what you're telling the court, but
Yes.
then Mr. Hale responds, you know you can't do this without a court order. You're taking advantage of the legal loophole, and it's very noticeable, both with the children care and my house. He's complaining to you that you're not allowing him his rights to have his home
He-
and to visit with the kids. Isn't that true?
He was allowed to go into the home.
And so then why is he complaining?
I don't know.
You don't know?
He's unstable.
Now, you're claiming he's unstable, but
Yes.
the court just saw that a month ago, you allowed him to take care of the kids while you were gone out of town.
Again, I'm gonna repeat the marriage counseling and the fact that there was suicide threats. I was trying my very hardest to make sure he was okay mentally.
When
and
were the
making him-
suicide threats?
They were prior to throughout the pregnancy, prior to February. I have a phone call to 988 suicide hotline after telling Mr. Hale that if he continued to threaten to take his life, I would call 988, and I did
What year was that?
this year,
What month?
February.
February.
Yes,
And you said it was throughout your pregnancy?
he has threatened throughout the pregnancy that, thank God he sold his gun, because if not, he would blow his brains out.
What child were you pregnant with when he was making the
Oliver.
threats? And what year was Oliver born?
2025.
Okay, so how did he make threats while you were pregnant in 2026?
No. While I was pregnant, he made that threat. He made another threat next after Oliver was born.
So what you're
In
telling
this
this,
past February, he made another suicide threat.
so what you're telling the court is that Mr. Hale made suicide threats,
Yes,
was physical with the kids. You felt scared, and yet
Yes.
throughout what we just saw, you have allowed him to take care of the kids while you're at work.
I had no other choice.
So the
At
answer
the
is
time.
yes? The answer is yes?
Yes.
Okay, thank you. Now, Judge, may I call up exhibit number 10?
Court staff will prompt.
Mr. Hale is asking you in the blue that he wants to see Nika and Ollie,
Yes.
and you told him, get used to standard visitation. Why did you say that?
Because we had discussed visitation prior. We had been talking about that, and so I said standard visitation was probably what the court was going to rule, because I've been through this process before, so when parties don't agree, usually it's standard visitation. That's why I said that.
So you decided to choose standard visitation.
We talked about it.
And you know we're asking the court for a 50-50 possession split, correct?
Correct?
And you don't agree with that.
No, sir.
How would you like it if the court gave you standard possession and gave my client custody? Would you be okay with that?
No, sir.
Okay. He also tells you that he doesn't know where the kids are and he doesn't know what standard visitation, but he doesn't want it, right?
And the text,
Yes.
I didn't, can I see it
Can you
again?
bring up exhibit number 10, please, for court staff?
Go ahead.
And if you can scroll down the message. And if you could scroll down a little bit further. And in return for him asking you that he didn't want standard, you told him, I already told you it's going to be standard. Tell your mom to leave me alone. And my client responds, got it, correct?
Yes, sir.
And now in exhibit number 11, if the court staff could bring up number 11.
Go ahead.
Mr. Hale is talking on the right side columns and you're talking on the left side columns. And he's telling you that your way is unreasonable. Isn't that true?
No. Well, he did text that, yes.
Right. And then you told him, I don't want you near me, and you don't respect that. And he
Yes.
says, I'm obviously offering you the house, right? Which is what you said that he moved out.
Mhm.
And you told him, ask Donald what will happen if I decide I want to call the cops for a domestic dispute. Who is Donald?
Prior to these messages that you're showing, he
Well, who
told
is Donald, ma'am? Answer my question.
Mr. Hale's uncle that works for Laredo Police Department.
What's his name?
Donald Hale.
Okay, and you told him, ask Donald what will happen if I decide to call the cops for a domestic dispute. My client responds on the screen, you're not understanding. You'll need to step away and see someone. He's telling you that you need to go see someone, correct?
Before that text,
Hold on, ma'am. I'm
It's-
talking about this
there's
text, so
there's
please answer my
pieces
question.
missing where he brought up Donald first.
Judge, may I ask for the court to instruct the witness to answer my question?
You need to answer the questions. Go ahead.
What was the question? Okay, I'm sorry.
He told you that you're not understanding, you need to step away and see someone, right?
I don't know if he means an attorney or if he means another police
Well,
officer.
whatever he meant, he told you you needed to see someone, right?
Sure, yes.
And this was in response because you're telling him that he needs to ask his uncle what the cops will do if you call them, right?
Yes,
Okay, and you said, who will they remove? Question mark. What did you mean by that?
who will they ask to leave the house?
And who are they gonna remove?
Usually they allow the mother to stay with the children.
And
That's what
they
I've
could have
known.
allowed him to stay at the house with the kids, right?
But I have two other children that live there that are not his.
And then, oh, by the way, that's a good point. Your other two children,
Yes,
what did you say their names were?
Isaac Guerra and Ellie Saldana.
One is 13 and one is 9.
Yes,
Throughout your 3 years of marriage with Mr. Hale, you
Yeah.
have allowed Mr. Hale to care for Isaac and Ellie, correct?
yes,
You have allowed him to pick up the children at school? Yes?
yes, I had to.
You have allowed him to drop off the children at school?
Yes, I had to on occasion.
You have allowed him to take care of them overnight while you're at work?
I had a full-time job for the federal government. Yes, he did a lot of that work.
Okay, let me go back to exhibit number 11. You told him who will they remove, and he tells you more threats, and you tell him, ask him, I could be a bitch too. Why are you telling him that you could be a bitch?
Because he was being a bitch.
He was being a bitch?
Yes.
Did you tell him that on the text?
No, he was acting a certain way, and so if he wanted to act that way, I can do that too.
Okay. Where do you work, ma'am?
World Trade Bridge,
What is your position?
agriculture specialist,
How much money do you make per year?
about $110,000, 120, depending on overtime, night differential and holiday pay.
Did you file your income tax return for 2025?
Yes, sir, I did.
How much did you claim in your W-2 for 2025?
I'm not sure of the exact amount right now.
Do you have a copy on your phone?
Yeah, I probably do.
Do you want to look for it?
My phone is dead.
Your current salary is at least 110,000,
Yes,
and you have 2 children who are not before the court,
yeah, in different relationships.
and there is 2 children before the court.
Yes, yes.
Do you know where your husband works?
He is self-employed
Where?
at Power 5, the business we started together.
Where else does he work?
I think he started working at Orange Theory and Crunch and another commission-based athletic gear, some sort.
And so your husband is involved in the athletic business, correct?
Yes. That's new, yes.
Would you be willing to vacate the home to allow Mr. Hale to live there?
No. I cannot risk him leaving anything or planting anything that would jeopardize my job.
How would that jeopardize your job?
He's using medical marijuana, and I don't know that that's a good idea. I cannot be associated, live under the same roof, share spaces with somebody who's engaging in that.
So you're telling us that if somebody has a medical prescription, that's not good enough for your job, for your employer?
That's correct.
And Mr. Hale is not employed by the federal government, correct?
No, his wife is.
Okay, so you could leave the house to avoid that problem?
No, I cannot share a space with him.
Mr. Hale has the same right to occupy the home, correct?
Yes,
And he has 2 kids who live at that home, right?
yes,
Would you be willing to allow Mr. Hale to live at the house when he has possession of the children?
no,
Do you have a mother and father who live in Laredo?
I do.
Could you not stay with them, with your other children, while Mr. Hale exercises his visitation with his kids?
Would he like me to take my older kids with me too?
Yes,
No,
you're not willing to do that.
I don't think that's a rational thing, no.
Do you
to
have
ask
health
the
insurance
older-
for the children?
I do.
And how much are you paying for the health insurance for the kids?
I'm not sure of the exact number.
You pay health insurance for all 4 kids?
Health, dental, vision, yes,
For all 4 kids?
for all 4.
Okay.
It was agreed in prior orders based on child support amounts and whatnot, yes.
I have no further questions for the witness, Judge.
That was Cross. Anything on redirect?
When did your trust of Mr. Hale change, Mrs. Hale?
It was within the last month or so with the CPS, when the CPS case came out, that report, I realized how deeply rooted this use was, and it was more of validation for me that somebody else also thought that this behavior was concerning, not just me.
What have you observed of Mr. Hale's behavior towards the children?
At the moment, right now, or?
Yeah.
um,
at the moment.
He cares for the kids whenever it's his time to care for the kids. I'm not sure how many times the question.
Pass the witness, Judge.
Anything on recross?
No, Judge. I would just
All
like
right,
to offer exhibit 9, 10, and 11, which were talked about during first reading.
Any objection to the
No
admission
objection,
of
Judge.
exhibits 9, 10, and 11 are admitted
I called,
without objection? All right, Ms. Hill, you may step down.
Thank you,
Mr.
Judge.
Derek, Andrew Hale, Judge.
The court will pause. It is, Mr. Hill, you may have a seat. So we'll go to 4:30. It's 4:36. I was looking at the calendar, Mr. Chu and Mr. Vela. There's really only one time slot that I could devote to this. But before I do, Mr. Chu, how many more witnesses do you have?
Just have Mr. Hale, Judge.
And Mr. Vela, how many witnesses do you have?
Just Mr. Hale, Judge.
How much time do you anticipate reasonably with this witness, Mr. Chu?
I would probably spend about 30 minutes with Mr. Hale, and so probably an hour between us, I believe.
Mr. Vela?
That's correct. I think Mr. Chu is correct.
All
30,
right,
30.
let's come back unless you all have an objection, and I'm gonna be pressed to give you anything in the next 3 weeks. But we will reconvene this hearing. No changes to any orders. The status quo remains until Friday, May the 8th at 9 a.m. Thoughts, comments, or objections, Mr. Chu?
Yes, Judge. Does that mean that Mr. Hale still stays out of the house?
That means whatever's in place right now doesn't change until I can hear the full set of evidence and make a decision.
Thank you.
Judge, there is no order prohibiting my client from being at the home. There is a standard temporary restraining order that was signed by the court. There is no order prohibiting visitation. And so I don't understand why they're saying we can't go to the home. And also why we can't see the kids.
I'm gonna reiterate what I've said. So there was this, and I think I remember because I was looked to see whether the only thing that really stands out, usually all things being equal in these cases, is whether exclusion is requested. And I don't think I just don't remember that in this case, unless you tell me different, Mr. Chu. So I'm gonna just reiterate what the court has already said. Any orders currently in place remain, stay valid and in effect until Friday, May the 8th at 9 a.m. when we resume. Now, if there's any issues, Mr. Chu and Mr. Vela, just flesh it out in first testimony and then argument as to what happened and why and what should have happened in case it didn't. And that should also assist the court in making the most and best appropriate decision. Anything else on this case, Mr. Chu?
Yes, Judge. We did request an exclusion in our temporary order request. So if I can.
You requested an exclusion. How did the court receive and interview Sylvia Hale and hear testimony from her?
Yes, we did. I had asked her
At the time that the order was signed?
At the time that the order was signed, we had requested an exclusion, but that's normally doesn't take effect until after. you
It can't be
decide in the year.
it can't be granted unless there's an in-person, not examination, but an in-person testimony. I don't even think an affidavit suffices. I think it has to be an in-person. It's not even an interview, but the evidence has to be in person. Let me ask I can't believe I would have signed that. Give me 1 second.
No, Judge, you didn't grant the exclusion at the time of signing. It was gonna be granted after the hearing.
I think with Mr. Chu saying that he is requesting exclusive use of the home, but there is no order excluding my client from the house. That's why we're having the hearing. And she's been keeping my client out of the home. Not allowing my client to see the kids. I would ask the court to order that she allow my client to visit with the kids today and that he keep them overnight and return them to her tomorrow.
So we just asked for the court just to keep everything the way it is until at the conclusion of our hearing on the 8th.
One more time. So I think we're all saying the same thing. We arrive at different conclusions. So we've already started this hearing and the court is making 0 changes to the court's orders. So act accordingly. If any person is unreasonable or controverts those orders for any reason or does something outside of what is standard and normal or ordered by the court, then I'm going to deal with that situation on Friday. Ms. Hale, Mr. Hale, I wish you both very well. We'll continue on Friday. Good luck to all.
Thank you, Judge.
Thank you, Judge.
That concludes this hearing.